Senior Mr. R. Ali is not well since this morning. My lord. Maybe list in next week.
Okay, on request on behalf of RRL, list of the one and two separate orders.
One and two and three. Two and three.
Two and three. Bless.
May I please, Your Lordship, I beg to mention
That
three
will sure.
WPC Lordship. Three are a motion matter which was filed on March, Lordship. So kindly matter may be taken on 23, Lordship.
We'll have it on 28,
Lordship,
28.
Lordship 27 because 29 is our Eid and we are going to 28, Lordship.
Okay, 27.
27.
May I please, Your Lordship? Well, this matter kindly be listed on 21st of June 2023. Well, this is the contempt matter, the leftover matter, Your Lordship.
27.
Must I beg to mention item 22. My lord, I am appealing for the railways. My lord, I have taken consent of the petitioner.
No, 22 is adjourned by the petitioner himself.
My lord.
23.
23 was adjourned.
22 also was adjourned. E. Sharma.
22, no.
Hmm?
22 to Quran.
24. Okay, please. Yeah.
22, my lord.
Hmm.
I am appealing for the railways. My lord, we have taken consent of the petitioner.
Hmm.
Lord, need be adjourned today, my lord, because the conducting council, my lord, there is a water logging in front of his house. My lord, he could not come. So, my lord,
Okay, on request made by H. Gupta.
My lord.
Then the CGC.
my lord,
This the matter after 2 weeks.
2 weeks.
Okay.
Oblige.
May I please, Your Lordship, I beg to mention for item number 131, 44 and 45, Lordship, conducting council FU Borguya. His sister was expired on this morning. He is on his way to Hailakandi, so kindly matter may be taken up after vacation.
Item
Item 131, 44 and 45, Lordship.
One.
okay, on request made on behalf of Validity and the petitioner. List after 2 weeks
After vacation, Lordship.
after the summer vacation. And item 40,
44 and 45, Lordship.
same order.
This matter, there is urgency in the pension matter. Due to the impugn order, the petitioner stopped receiving the pension. So there is urgency. You file on Friday. Can it be on the 21st? That is on Wednesday.
You filed it on Friday, 23rd.
There is urgency. That is
That
why.
is why I'm saying 23rd. Otherwise, I'll put it next week.
Highly obliged.
Lordship, I beg to mention item number 13. This matter may come after application, Lordship.
Why?
I missed one, enclosed one order, Lordship, court's order. My mistake. I need to file additional affidavit.
You are Mr.
As you Ahmed.
Request made by S. Ahmed, then the conflict of petitioner, list after summer vacation.
May I please, Your Lordship? Your Lordship, I beg to mention item number 43.
Why?
Your Lordship, we have filed affidavit in reply, Your Lordship. On other side, they are yet to file a counter affidavit, Your Lordship. The matter may come after vacation, Your Lordship, for admission hearing.
Item?
Item 43,
You have four?
petitioner
You are Miss. Miss.
F. Shaheen,
You are appearing on behalf of
Mr. R. Hussain, Your Lordship.
item 40.
43. 43 of daily list.
On request made by MS.
F. Shaheen.
If signing on the council, the list of the summer vacation. Yeah.
Much obliged.
39 of daily list, personal appearance for order.
May I please, Your Honor? Your Honor, matter may be adjourned for the time being.
No, just the personal appearance. Yes. Proceed. Yes. What is your case?
Actually, Your Honor, petition was a mentally disabled person. So, Your Honor, he has filed a application for the disabled pension, Your Honor. So, Honorable Court has already passed an order, page number 8, Your Honor, in the contempt case.
Yes.
May I, your lordship? Lordship, in this matter, your lordship, by order dated 15/5/23. Honorable Court was pleased to direct the appearance of respondent number 1. But that concerned respondent number 1, who is present before this honorable court, he got retired from his office on 30/9/2018 itself. 30/9/2018, your lordship. On 15/5/23, your lordship, due to some inadvertence, the concerned counsel for the respondent number was not present. Lordship, I had filed my wakalatnama newly for respondent number 3, who is the newly implemented respondent, the director of pension, your lordship. Lordship, I had furnished your lordship, the communication dated 16th May 2023, your lordship. And I had the talk with them also. They have said that they had, since all of the relevant documents that are required has already been furnished now. So, your lordship, the district elementary education officer, they told that they will meet and submit the entire that is required within a period of 2 weeks. So I pray for your lordship for granting 1 month time. Within that, the grievance would be met. The matter related to pension in this matter.
Yes.
Your Honor, so many times where petitioner has already filed the all related documents, Your Honor. Your Honor,
Now
but
that he has been found to be what suitable for family pension,
yes, Your Honor.
and the director pension has written to the concerned authorities to resubmit the pension papers.
Already, you know, so many times he have submitted the papers, but the office
That is the latest development of 16th May 2023.
yes, sir.
Yes, you are Mr. You have responded.
Number 1, I retired on 30th September 2023.
2018.
18.
2018.
18.
You don't know your retirement date or what?
30/9/2018.
You are retired.
Yes.
When was this order passed?
It is on 15/5/23.
No.
9/9/2017, my lord.
2017.
No, for his appearance.
He was personally appear, my lord.
2017, this order was passed
Yes, Your Honor.
to pass appropriate orders within 15 days. That is before your retirement.
Yes.
So before your retirement, what were you doing?
I had sent a matter to the concerned authority for resubmission of this matter with
No, my lord.
documents.
One minute.
No, my lord.
1 minute. Yes.
But by this time, I have retired already. When
This order was passed on 9/9/2017, before your retirement. I want to know what you did before your retirement, because you were supposed to pass appropriate orders within 15 days. What took you so long? You didn't do anything before your retirement. You're slipping over the matter.
no,
Then what were you doing before your retirement? When did you receive this copy?
Necessary initiative, necessary procedural people.
I just
So for the relief.
sorted the for sorting the matter. I communicated with the DU concern for
When?
resubmission
When?
in the July 2018.
July 2008. Order was passed on 9/9/2017. You were supposed to pass appropriate orders within 15 days. That is what I am questioning you about.
I was not aware of this order, particular during the time.
What is that?
That the file came to me within on 18 only, 18 June or July.
No, no, September. Order to say.
Yes, what are you prompting?
I cannot recollect this.
Yes, what were you submitting earlier?
Lordship, since he's misinterpreting it as June or July, your lordship, since it has been passed on 9th, your lordship, September date.
Yes, heard MS,
Your Honor,
your good name?
P. Deka.
P. Deka, learned counsel for the petitioner. Stop. The respondent number 1.
May I please, Lordship?
Yes.
Lordship, when the order was passed, he was personally appear before the honorable court, my lord. In this first line of the order, my lord. Are present Mr. Bhavesh Deka, Director of Pension, along with Mr. A. Setri, Learned Counsel, are present, Your Honor. When the order was passed, he was personally present, my lord.
Yes. You are present on that day
Yes, sir.
when the order was passed. How can you say that the file reached you only on 2018? You answered that question. When this order was passed by the Lok Adalat, you were present on that day and you were directed to pass appropriate orders within 15 days. What did you do? Why are you keeping quiet? I'm asking you a question. Why can't you answer that question?
I forgot this, all this matter during these things. During this period. I can't recollect what was actually.
The day when this order was passed.
Yes.
Give him the order. Show him the order.
Sing.
Get your passport.
Mr. Bhavesh Deka, Director of Pension, along with Mr. A. Chetri, Learned Counsel, are present. That is.
You refresh your memory. I'll take up at 11 o'clock. This matter. You refresh your memory and come back.
Item 4 of daily list, motion.
Well, the matter relating to the completion of payment.
Yes.
His father died on 2011, madam.
Yeah.
And madam, on 23 to 2011, he filed an application before authority, madam.
23?
23 to 2011.
Yeah.
After that, madam, the DLC madam kept the paper pending, madam. On madam, 29/9/2022, I filed an application, RTA application, madam. And my in the RTA information, madam, kindly have a look, madam. Page, my lord, 19. Paragraph 2, madam. Is there a reply? Married. Your proposal was placed in a DLC meeting held on 18/8/2011, 21/4/2012, and 16/3/2013, and was not recommended. Further, it is seen from the records available in this office in respect of the appointment under compensation ground in the district of Lakhimpur that only the recommended candidates list were recorded in the minutes, and the list of rejected candidates were not recorded in the minutes at that period of time. And that my rejection matter, on the what ground matter, I was rejected, but that was not placement, that was not on the record. And it's
Yes, Saikia,
on similar ground matter. The lordship has passed.
you have not given any reasons.
My lord, they have, my lord, take up the matter 2011, 12, and 13 matter.
That we know.
Three occasion matter.
On three occasion, what is the reason for non-consideration,
My lord,
for rejecting this matter?
my lord, that ground not available, my lord. Because, my lord, as per the instruction of the deputy commissioner, my lord.
I don't-
That point
In
of time,
similar matter, your lordship has passed this order, the same issue.
This is a different thing. Here the reason was given.
No, not me. That, in that case also, my reason was not given.
Reason was not given
None given.
after the government
Say-
advocate came with the plea that it was because of lack of 5% vacancy.
No, the reason was, in this case also, my reason was not given.
In this case,
My lord.
here he is not coming with any instructions.
my lord,
What is your instruction?
my lord, some time will be required, my lord. Because, my lord, 2011, 10, 11, and 12.
Where are these minutes?
That is not available with.
In the minutes also, it is not
My lord,
recorded.
I'll produce it, my lord. Within 1 week, my lord. I'll produce it. Both cases, my lord.
Third, Mr. X. Hanikal and consecutive commissioner. From Mr. P. Saigel and government advocate. Shall produce the minutes of the DLC meeting held on 10/8/2011, 21/4/2012, and 16/3/2013, as well as receive instructions as to why the case of the petitioner was rejected by the DLC in the aforesaid meetings. Stop. List the matter after 2 weeks.
Second case is also, my lord, similar, my lord.
Five.
Five also.
Similar matter,
Similar.
My lord.
same
Same
DLC,
issue, same deal.
same DLC.
Same deal.
Where's the page?
Page number 23, my lord.
On 21/4/2012, 16/13, and 18/12/13.
Page number 23, my lord, and Excel,
Same order.
my lord.
Diploma.
6.
Maybe little. In this case also large occasion government has take some time for file affidavit in opposition and some instruction, but till date they have not filed affidavit.
তোমালোকে টাইম লৈছিলে নেকি লাষ্ট ডেট
Government, large occasion government.
Huh?
Government affidavit in opposition.
Only 6:30. To 7 or 6. 7. No, 6 or 7. 6.
Yes,
My lord, in this matter, my lord, today they have sent the instruction. My lord. It cannot be taken up, my lord, after some time or my lord, any other day, my lord.
but Mr.
As new.
S. New Clone Council Procedural are requested by Mr. P. Cycle and Governor. List the matter after 1 week.
Master Bliss.
7,
Wait, please, my lord. Conducting counsel is stuck in waterlogging, my lord.
So what do we do?
My lord, next matter, can it be passed over for the time being, my lord?
What is this case about?
My lord, it's regarding provincialization of school where the other school was made the base school
Hmm.
and we were asked to join it.
Then,
We are appealing against the same, my lord. My friend was supposed to conduct the case, my lord.
you don't have the brief.
I have the brief,
Why can't you proceed?
my lord. My lord would kindly come to page 11 of the writ petition. The base school order is in page 11.
Yes.
We are employees of Takar Dole ME school and we have been told to join the MMK ME school.
Yes.
Now, my lord, this is governed by the provisions of the Assam Education Provincialization of Services of Teachers Act 2017, wherein there is an explicit provision, section 12 of the said act. If I may read the same.
Which act, 2000?
17 Act, my lord, the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017, my lord.
Yes.
If I may read section 12 of the same, my lord, which talks about, which deals with amalgamation and merger and shifting or expansion of educational institutions. Now, my lord, the said section says, in appropriate cases, if there is already an existing education institution nearby and the enrollment of the students do not justify more than one institution in the same locality, or there are other sufficient reasons to do so, the state government in the public interest and for reasons to be recorded in writing may order for transfer or shifting of the said institution. Subsection 2, in appropriate cases, if the state government is of the view that an existing educational institution needs to be expanded so as to have more classes, the state government may, by order, make expansion of an existing educational institution from primary to upper primary, from upper primary to secondary, and from secondary to higher secondary, or reverse. Now, my lord, in our case, my lord, we have been directed to join the MMK school. We were designated as headmasters, assistant teachers in our parents' school, that is the Takar Dole school. Now, my lord, we have been designated as tutors, we will be downgraded. And my lord, moreover, the other school, it is quite far from our existing school, my lord. So the
What
students
is
were,
the distance?
my lord, it is more than 7 kilometers. Again, my lord, if I may refer to section 6 of the said act only. My lord, section 6 of the 2017 Act says, the government of Assam shall identify base school for the purpose of provincialization of teachers of venture education institutions so as to fulfill the norms and standards required for providing educational institutions within the specified area. My lord, ours is a lower primary school within a radius of 1 kilometer. My lord, this is crossing the said limit, my lord.
Yes, section,
My lord, section 6, subsection 1.
subsection
1.
1.
My lord, we have it at page 972. 972 of the act.
Same act, isn't
Same
it?
act.
Read it.
The government of Assam
No.
shall identify base school.
2017 act,
My lord,
section 6.
my lord.
Section says something else. Education and professional qualifications of teachers.
My lord comes to page 972.
This book,
My lord, the 2017 Act itself.
2017 exception.
17, my lord, section 6.
I'm on 2017 Act.
My lord, I am finding this in section 6.
Alright, then you don't have this book.
My lord, I have the act printout. I don't have the education manual, my lord.
Just check up, Burma.
My lord,
Just check up. Section 6.
my lord, at this stage notice may be issued. I will take instruction, my lord. And
You,
as
what
per
is your ground for
2000
challenge to
as
this
per
order?
2011 Act.
My lord,
lord.
my challenge
No,
will,
my lord.
my lord will find at page 6 of the writ petition.
Yes.
My lord, the academic atmosphere of our school will be hampered, my lord. And my lord, it will not be appropriate under the said essence of section 12, as I had already read out. You know, appropriate cases, my lord, it is not an appropriate case. We are assailing that, my lord. My lord, moreover, the downgradation factor is also there regarding our posts. Since we were headmaster and assistant teachers, so we'll face a downgradation, my lord, as such.
Yes, Fukan.
Hello. Kindly, I may be allowed to take instruction after 1 week. Yes, ma'am.
But Mr.
Peers or not?
P.R. Sharma and counsel for the petitioner, MS
And
and Fukan, standing counsel. Elementary.
yes, ma'am.
Elementary division. Praise for 1 week time to
1
give instructions. Praise a lot. This of the 1 week.
8,
May it please, my lord. Similar matter against the base school order. My lord.
Yes, same order,
Same.
Same order, my lord. Would find at page 14 of the writ petition.
same order. You want to take instructions?
My lord.
9,
May I please your lordship? In this case, my lord, this matter pertains to transfer matter. In this case, lordship, the person in which place the petitioner got transferred, he has not been made party in this case.
Yeah.
So, my lord, last occasion we asked to file impleadment petition and we have filed, lordship. So this matter may be taken up at 2 p.m. along with the impleadment petition, lordship.
When did you file your impleadment petition?
Yes, today itself, lordship. At 2 p.m. lordship.
Let's see.
Published.
10,
Please, Lord. Here the petitioner's father was working as night chowkidar and he in the Lanka High School also, and died in harness on 11/6/2012. And thereafter the school management has appointed me on temporary basis in that said post on 10/10/2012.
On?
On 10/10/2012. But I am continuing, but the post, my application was not sent to the DLC for consideration, lordship. Now, if I take your lordship to
You made
page,
your application?
application was filed, lordship, but
Now
was
he is not
sent.
seeking on appointment on compulsion. Now he is the regulation of his service lordship. He was appointed by the managing committee.
Yes, lordship.
Now he wanted regulation with service lordship without appearing in the any selection process lordship. How can it that be lord?
Look, whatever it may be, lordship, after the death of my mother, lordship, the family pension which she was receiving, that has also been stopped, lordship. So only means of livelihood is this, lordship. And I am praying for direction to the Director of Secondary Education for disposal of my representation, lordship, dated 12/4/2023.
Even
Annexure
that
8,
not
page
existed,
37.
lordship. He was appointed in a provincial high school by a managing committee. Now he want regulation of his service lordship.
How can
That
that be?
cannot be.
Let my representation be disposed of at least. Let them take a call. to my representation because my application was not sent to the DLC lordship.
There is no point of considering his representation at this
Did
stage.
you make any application for appointment on commissioner?
Yes, lordship.
Where's your application?
Lordship at page 25, annexure 4. Prior to that also I made lordship. This is the second one. And prior to that, 2012, the application that is not access to
An
me at all.
application has to be in a prescribed form, not like this is normal representation lordship.
Everybody is not aware lordship in the prescribed format.
His father expired on 11/6/2012. He's filed this application on 9/8/16 after 4 years.
No, what he's saying is he has filed it prior to that.
Prior to that, lordship,
Where-
that is
where did you
that
file-
application is I am not access to this
No,
because I have not that was not received.
At least you should have some knowledge the day when you filed your application.
That is
and
there.
this petition,
That is there.
and this representation is for a compulsory appointment for regulation of service law.
No, I know that.
There is a prayer. Prayer is there, and or pass any other order or order. that-
Participate in the
Yes.
selection process only.
When
then
did you
lordship.
make your application? That is the what you want to.
I would keep taking it. I would police it.
Directing the respondents to regularize your service that this court cannot.
May not be, lordship. Because there should be a regular process lordship of
And
selection.
nothing remains. 2012 expired in 2012, not 23 lawsuits.
No, the only issue is he said he has made an application of.
In a proper form, if that is, if you can produce that
Let
lawsuit.
us see what they did. One is 2016, that is quite late.
And the school management committee is also at page 23 lordship.
The managing committee appointment him lawsuit in a provincial school, that cannot be lawsuit, that is itself is barred by this honorable court. Their judgments are there lawsuit. In a provincial school, managing committee. has
That
no
is
right
a
to
different
appoint.
thing. This is a different issue.
This is different.
You want a regular appointment because of the death of your father,
Yes,
that has to be by way of commissioner
Yes,
appointment.
yes.
compulsion.
And he have to,
And that commissioner appointment, you have to make your application
in a prescribed form.
on time.
Yes, lawsuit.
Within time.
Have you filed your application on time?
So for my instruction is that he has filed, but
When?
that copy has not been written by him, lordship.
But at least you
Yes,
should
sir.
know the dates.
Let it take time, lawsuit, if you can produce it.
Lordship, I'll take the instruction, lordship, when he has filed. Let it come up on Friday next. Lordship.
On request made by Ardhar, Mr. Ardhar, then for the petitioner. Placed for some time. To enable him to receive instructions. As to on which date. The petitioner made his application for appointment on compassionate grounds. Stop. List the matter again on when do you?
Friday, lordship.
This Friday.
Yes, sir. Or on 26th, lordship.
26.
Deep level.
11.
May please, your lordships. Lordship, these are two matters, item 11 and 12. They are substantially on the same facts.
What is this matter?
Yes, lordships. The petitioners in both the matters, they are presently working as assistant teachers under the BTC. Now, before I proceed further, lordships, on the merits of this case, it is necessary for me to apprise your lordships that on substantially similar facts, which they will also agree, another bench has issued notice, and that order also we have annexed.
Where is the total?
Yes, that order, lordship, will see at annexure 18, page 398. Of course, the impugned action, I must also fairly submit, the impugned action in this case and the cases that I wish to argue, the impugned action is only different, but besides that, the entire facts are the same. This order, lordship, will see is of 29th of May 2023. It's a detailed order. If lordship so wishes, I can place it. Lordship.
Yes.
Yes. Heard Mr. M. Goswami, learned counsel for the parties. The writ petition has a checkered history. The case of the petitioner is that he was initially appointed as an assistant teacher at Mazdia Junior Basic School, hereinafter for short referred to as the school in the district of Baska, erstwhile Nalbari, via an order dated 4/12/1999. She claims to have been receiving her salaries when suddenly in the year 2010, the services of the petitioner along with a host of similarly situated persons were cancelled. This led to first round of litigation, and the writ petitioners, including the writ petition filed by the petitioner being so-and-so, were allowed by this court primarily on the ground for violation of the principles of natural justice. The matter was accordingly remanded back to the authorities to take a fresh call. However, the rejection was upheld, leading to a second round of litigation, which, however, was dismissed by the learned single judge, holding that the initial appointments were illegal. The petitioners, along with a number of similarly situated persons, had preferred writ appeal. The writ appeal filed by the petitioner being so-and-so. This is specific to that. The Honorable Division Bench, now this is applicable, the Honorable Division Bench by an order dated 6/2/2015 had, however, disposed of the writ appeal as the Honorable Division Bench was apprised that a policy was adopted by the BTC for regularizing the teachers who were in a similar situation, and 221 numbers of teachers were already regularized. The Honorable Division Bench had accordingly passed a direction to give effect of regularization to such teachers. Though subsequently a review was preferred by the State Finance Department, the same was also disposed of by the Honorable Division Bench as the ground which was cited for review, namely lack of approval from the Finance Department, was also already rectified. In the meantime, the state's statement was recorded by the Honorable Division Bench. As a consequence of the proceedings in this court, the authorities have passed an order dated 22/9/2015, withdrawing the termination order of petitioner, and by another order dated 1/10/2015, the services of the petitioner was regularized with prospective effect. Since the petitioner and the similarly situated persons were still not paid their salaries, new writ petitions have been filed which are pending. It appears in the meantime, the BTC had made certain arrangements, and on 9/9/2016, an order of adjustment was passed. Subsequently, by an order dated 1/4/2022, the petitioner was accommodated as a tutor in the Mazdia Junior Basic School, which was on fixed pay. The petitioner projects that the accommodation, as the expression suggests, was temporary measure till the regular posting of the petitioner pursuant to the policy decision of the BTC, which was also endorsed by this court. Subsequently, on 14/7/2022, an order was passed posting the petitioner as a regular teacher in 786 Kalakuchi LP School in the district of Baksa. Though the petitioner submits that there is an issue on the use of expression regularized as to from which date such regularization would take place, the grievance of the petitioner is that even after joining by joining report dated 18/8/2022, the impugned order has been passed, cancelling the order dated 14/7/2022. Sri Goswami Learned Counsel for the petitioner submit that the impugned order dated 27/7/2022 is expressly illegal, as apart from the fact that no reasons have been cited and no opportunity granted to the petitioner before passing of such order, the background and history in this case do not at all justify passing of such order. So-and-so Learned Counsel also praised for an interim order to allow the petitioner to discharge her duties as an assistant teacher in 786 Kalakuchi LP School, where she was appointed on an existing vacancy. Issue notice returnable by 4 weeks. So-and-so Learned Standing Council, Education Department of Assam accepts notice on behalf of respondent number 1 and 8. A. Chalia, Learned Standing Council, Finance Department accepts notice on behalf of respondent number 2. So P. Nayak, Learned Council, Standing Council accepts notice on behalf of respondent 3, 4, 6, and 10, whereas so-and-so Learned Standing Council accepts notice on behalf of respondent 5. Let extra copies of writ petition be served. As regards the interim prayer, Sri Nayak, Learned Standing Council, BTC, has submitted that there is an inordinate delay on part of the petitioner in approaching the court. He further submits that it appears that from the impugned order, the arrangement of adjusting the petitioner as tutor, by the order dated 1/4/2022, has not been effected. The court has given its anxious thought onto the aforesaid matter. Though a prima facie case for passing an interim order is made out, the aspect of delay cannot be wholly overlooked. Therefore, balancing the equities, it is provided that the post in which the petitioner was appointed as a regular teacher by order dated 14/7/2002 in 786 Kalakuchi LP School shall not be filled up, if not already filled up, without the leave of the court. It is further observed that the aforesaid restraint would, however, not be applicable if the case of the petitioner is considered for putting her back in the said post. Let this case list after 4 weeks. So this is substantially, Lordships, the reliance of the learned single judge in this court. All these facts also arise in this case. So if Lordship will just in this background take up the first case, Lordships.
Yes.
Because here, the only difference here is, in this case, which the order which I read, here the order was issued and which was sought to be cancelled. We came against that cancellation. In these cases, after publishing the list, they are not handing over the orders. That is the only difference, Lordship. They are, for reasons best known to them, they are not handing over as those appointment orders after publishing the list where my name also features. I'll demonstrate it, Lordships. So therefore, Lordships will kindly see, Lordship, annexure 1 of this writ petition. This is page 50. This is my initial appointment. These are, of course, all admitted issues. This is my initial appointment, Lordships. 22/11/1999. Thereafter, what happened? It is necessary for me to apprise that there was a large-scale termination of orders in 2010 of these teachers on the ground that they were illegally appointed. Either they were irregular or illegal. So there was, across the state, there were large-scale termination of teachers. Now, all those teachers came up to this, which the learned single has noted that first round, the matter was remanded back. Then again, it came up. Second round, it went up to the appeal stage. Now, that appeal order is very relevant because that is the appeal order from which all the subsequent action flows. So may I just, Lordships, take Lordships to the order passed in the appeal in the first round, which is at annexure 3, page 54. And the relevant portion, Lordships, is at page 102. The long, because there were many petitions, all commonly decided. So the cause title is quite long, but the relevant portion is at page 102. Is Lordship at page 102? May I place this order, Lordships? Because this order will have some relevance. Heard the appellants and the respondents. The policy decision taken by the Borough Territorial Council is received on record. The appellants were teachers appointed and working in various ME, MV schools in the Borough Territorial District Judicial area. It is the case of the appellants that the appellants were appointed in the year 1999 and earlier thereto. The appointments of the said teachers came to be terminated as being illegal and that the appointment orders issued by the District Elementary Education Officer, Block Elementary Education Officer in Nalbari District were illegal. Therefore, the termination orders were issued by the Director of Education, BTC. This court in WPC 2182 of 2009 batch had found that the termination orders are illegal and remanded the matter to follow the principles of natural justice. The Director of Education redid the exercise and again terminated for the second time, giving the same reason. Aggrieved by the said orders, the appellants have filed the writ petitions. The learned single judge found that the order of appointment had been issued illegally and that the order of termination is legal. Hence, dismissed the writ petitions. Aggrieved by the said order, the appellants filed these appeals. It is submitted by the counsel for the appellants that the appellants herein were receiving salaries up to 17/10/2006 and thereafter the termination was effected. The BTC as well as the government of Assam took a decision to regularize those teachers who were in service and regularly receiving salaries up to 17/10/2006. May I just pause for a moment here? I'm in a better position. It is an admitted fact that with respect to these two persons, I have received regular salary up to 31/10/2010. I'll demonstrate it from the records. So I'm in a better position even than this. Has been in the first phase of exercise, it is submitted that the 221 teachers have been found to be eligible for regularization as per the above norm. It is the contention of the appellants that the appellants are also similarly placed and they should also receive the similar treatment at law. The counsel appearing for the BTC submits that the policy decision is taken that the persons receiving regular salary from the month of March 2006 would be regularized and the implementation of the policy is in process. The government of Assam has also agreed to the said policy. In view of the above submission, the writ appeals are disposed of with a direction to the respondents to effect regularization as per the policy decision of all those eligible teachers who were regularly receiving salaries up to 17/10/2006. Needless to say that if any of the appellants is aggrieved in the decision-making with regards to the tenure of the service rendered and receipt of salaries, they can approach this court by separate petitions. Now, after this, Lordships, this is followed by two things. I must also point out that when I was not a party in these appeals. I was not a party, though I'm covered by the principle laid down. However, I filed my own separate writ petition thereafter, which was also disposed of in terms of the order passed by the DP. That order, Lordships, is at page annexure 4, page 104. This is my writ petition. If Lordship will see, Nogen Chandra Das, annexure 4, page 104. And this writ petition is disposed of in terms of the order passed by the division bench. Thereafter, Lordships, following the order passed by the division bench, please, Lordship will come to annexure 6, page 111. Following the order passed by the division bench, my termination is withdrawn. May I just place it? In pursuance of the BTC Executive Meeting Resolution number 4.1 dated 27/4/2015 and Resolution number 4 in the minus of the Department Meeting of Education Department held on 26 June 2015 respectively, the Borough Territorial Council is pleased to withdraw the termination order issued by so-and-so dated so-and-so against Nogen Chandra Das, Assistant Teacher, Doronga ME School, in terms of Director Elementary Education order dated so-and-so, with prospective effect. This is followed by my regularization, which is the next page. Now, this order, I may like to place it in extenso because it has some relevance, Lordship, because Lordship will mark the date 29th of October 2015. And it says, in pursuance of the Honorable Guwahati High Court judgment and order dated 6/2/2015, which I have already read to your Lordships, passed in writ appeal 182 of 2013, batch in the event of miscase number so-and-so filed by the BTC and consequent upon BTC Executive Council meeting resolution number so-and-so dated so-and-so and the departmental meeting Education Department resolution number 4 dated 26/6/2015 respectively. And in consequence with the approval received from the BTC by letter number so-and-so dated 17 October 2015 and on being termination order withdrawn by BTC by order dated 17 October 2015, Nogen Chandra Das, who was terminated from service by order number so-and-so dated 22nd October 2010, issued from this end is hereby withdrawn and his services is regularized/reinstated as assistant teacher in Doronga ME School in the scale of pay of so-and-so. And the number 1, the regularization of the service of an individual shall be subject to the following conditions. So may I just pause here for a moment? This order is still not withdrawn, not assailed, and it still stands. Neither rescinded, neither withdrawn, neither assailed by anyone. Now, thereafter, what happened, Lordships? Despite this order, we were not being paid salaries. So we came back to the court. And a bench presided over by Justice Pathak, M.R. Pathak, he passed an order which has also some relevance. But prior to that, the BTC itself, in fact, Lordships will kindly see that, Annexure 8. This is the order, again, a batch of writ petitions, and the Annexure 8 at page 113, and the relevant portion, may I read at page 328. Order dated 24/11/2022. May I place it, Lordships? After the order of the court, I'm so sorry, 328, Lordships. The relevant portion starts at page 328. Order dated 24/11/2022.
Yes.
Yes. After the order of the court dated 6/2/2015, passed in writ appeal number 182/2013, relating to termination of illegal teachers serving in the BTC areas, the authorities in the BTC took a policy decision and reinstated them in service and also regularized their services subject to the following conditions that. We'll just skip the conditions that may not be necessary. Petitioners, para 2, petitioners are claiming that their services have been regularized prospectively from 1/10/2015, but they have not been paid salaries, though they are serving regularly in the respective schools after provincialization of their services by the state by the order dated 1/10/2015. Hence, this writ petitions by the petitioners for payment of their monthly salaries, including the arrear salaries. Earlier, the court on 2/8/2022 and 23/8/2022 directed the respondents in BTC to pay salaries of the petitioners, more particularly their regular salaries with effect from August 2022 till disposal of these writ petitions, except those petitioners who have retired in the meantime. The learned counsels for the petitioners placed before the court that in spite of the orders dated 2/8/2022 and 23/8/2022 passed earlier in these writ petitions, the respondents BTC have not paid any salary to them since October 2015 till date, nor filed any proper affidavit in these matters. In one of the affidavit, that paragraph Lordship may skip, Lordship may directly come to para 7. During the deliberation of the matter, Mr. S. Bora, Learned Standing Counsel BTC, placed a communication number so-and-so dated 23/11/2022 issued by the Director of Education BTC Kokrajhar pertaining to status of joining and payment of salaries to the 1999 reinstated and regularized teachers in various lower primary and upper primary schools under the BTC, stating that 1,009 numbers of such teachers have been reinstated whose services have been regularized as assistant teachers in various LP and ME schools under the BTC in the process of regularization as held in the first phase on 14/7/2022 and in the second phase on 30/9/2022. I am just pausing it for it is the 30/9/2022 where my name is there. But despite this action which they apprise the court, they do not hand me over the appointment order. They come to the court. So that is my principal grievance. That today, when the whole process is over, my name is in the list. Why are you preventing me from joining? Please at least hand me over my appointment letter. Where do I go and join? So this aspect, because this was apprised to the court, that first phase 14/7/2022 and the second phase on 30/9/2022. I'll demonstrate it from the records. Now, after this lordships will come to Annexure 10 at page 335.
Okay.
35 lordships, Annexure 10.
Yes.
Now, as lordships have now realized that despite we being regularized, we are not getting the salaries. So therefore, a suggestion came from the BTC itself. And that is very important. It says, why don't you adjust these teachers against vacant posts so that this whole problem is sorted out once and for all. And therefore, lordship will kindly see para 3 of this letter. The teachers numbering. Is lordship got that paragraph, lordships? The teachers numbering 668 whose services have been reinstated may be adjusted against the said vacant post if BTC so desires for permanent solution of the long-standing issue before the BTC, and the remaining 915 posts may be advertised for TET passed candidates after receiving SIU approval. And this communication is from Director Education, Poro Territorial Council. Now, I understand, and the list of 668 teachers is at Annexure 11, page 39. And for lordship's convenience, this is the list of 668 teachers. I am at serial number 70, page 395. This is the
Serial number?
Serial number 70, page 395, lordship will kindly see. Nogen Chandra Das.
Yes.
Pursuant to this, well, lordship then comes straight to Annexure 15, page 386. Is lordship at page 386? Annexure 15. Despite all this thing, we were still not being paid salaries. So perhaps the government found a via media. What they did, they took up these people and appointed them as tutors on fixed stay. Accommodate them, not appointed. That is the word. That for the time being, at least let us pay you something. Because we are not in a position to pay you regular salaries, the matter is pending. So they took up these people and appointed them as tutors. I am one of those persons who have been appointed as a tutor. This is accommodated as a tutor, and this is the order 11th April 2022. If lordship will see, in persons of government approval communicated by so-and-so, the Secretary Education Department BTC's approval letter number so-and-so dated 24/3/2022 and subject to satisfactory police verification report and production of physical fitness from Joint Director Health, the following candidate is hereby accommodated. Please mark the word. As tutor in LP UP school on purely temporary basis in fixed scale of so and so under DEO Baksa, and my name is Nagan Chandra Das, Salmara Milan ME School. So for the timing, I was accommodated as a tutor. This was then followed by Annexure 16, which is now where we come to the impugned action of the state. Please see, this order is of 30th September 2022. The same date which I had Lordship earlier marked, which was apprised to the bench of Justice Pathak, that we are doing the second. This is the second phase order. Date is 30th September 2022, and it says ceremonial distribution of appointment order, the subject. Sir, with reference to the subject cited above, I would like to inform you that a ceremonial distribution of appointment order to reinstated teachers, assistant teachers of UP and LP schools appointed in the year 1999 is scheduled to be held on 1/10/2022 at the premises of so-and-so school, wherein the Honorable CM will be present. You are therefore requested to make the following arrangements for distribution of the appointment order. And the list is also annexed to this annexure. And my name is at page 395, serial number 70.
Yes.
Thereafter, Lordship, the appointment order is not done.
We are grieved because of that.
That is. We filed a representation, there's no response to it. So we really don't know. We are now stuck up. So this is why I have Lordship approached this court.
May pleases your Lordship. Your Lordship, similar matter is on your Lordship page number 398, your Lordship. Similar matter, your Lordship. Kindly matter may tag your
No,
Lordship
we will
along
pray
with
for
the,
tagging, no doubt.
along with writ petition 3009/23. Here already notice has been issued, your Lordship, and the returnable after 4 weeks. So it may tag along with 3009/23. Similar matter, your Lordship.
So that I had already placed, Lordship, at the very outset.
Annexure 18.
The only difference between this case, Annexure 18, and this is the dates could be different and the schools would be different. Lordship.
Similar matter, your
But the
Lordship.
principle is same. No, that I have already apprised before.
Yes.
It may tag along with the 3009/23, your Lordship. It may.
But why are you not handing over the appointment orders? That's the only issue in this.
I am so grateful, Lordship.
Your Lordship, we need to obtain instruction, your Lordship. Let the notice may issue.
Okay, heard, Mr.
But Lordship, I am praying for a interim protection. What may
No,
be
your
similar
Lordship,
to the-
in, no, your
Let
Lordship.
me submit. I'm sure when my leadership, my friend will submit, I'll not interfere. But let me at least submit. In the previous order also, there is an interim protection. So I seek an interim protection to this extent that one post may not be filled up. Because they cannot today ask for tagging and then go and fill up the post. Then my whole writ petition becomes infructuous. Because in the previous case also, there's an interim order passed. If Lordship will see the last interim order, that one post will not be filled up without the leave of the court. Please give me a similar writ petition. I'm only praying for that. A
Your
similar
Lordship.
relief, Lordship. I'm not asking for anything excess.
Lordship, let the instruction be received, your Lordship, and on the very next date, your Lordship, it may consider, your Lordship.
When can you come with instructions?
They can take a
Your
telephonic
Lordship,
instruction.
after 4 weeks, your Lordship.
Why 4 weeks? for
Your Lordship,
instruction?
already matter has been, your Lordship, in matter writ petition number 3009, that is similar, your Lordship, which has been annexed.
That I've seen.
Yes, your Lordship.
There's
So,
a slight difference between this writ petition and the present writ petition.
There what happened, the order
Your
was
Lordship.
passed and that was sought to be cancelled.
Yes.
Here they are not passing, giving us the orders. So all that I am saying is the innocuous, it is the
Your
innocuous.
Lordship, 3 weeks, your Lordship, because BTC Kokrajhar, your Lordship, we need to obtain instruction, your Lordship. So, your Lordship.
Heard, Mr.
M. Goswami, Lordship.
M. Goswami, legal counsel for the petitioner. Issue notice. MS.
P. Das, on behalf of B. Chaudhary, standing counsel, BTC.
P. Das, legal counsel appearing on behalf of P. Chaudhary, legal counsel. Legal standing counsel BTC appears for respondents.
BTC, your lordship.
3, 4, 6 and 7.
3, 3, 4,
6.
6.
Who
and-
appears for elementary?
I'm appearing now.
MS, so understanding council.
Respondent 1 and 5.
Appears for respondents, 1,
1 and 5.
1 and 5, and Mr. P. Chalia, respondent number 2. Standing council, finance department appears for respondent number 2. Stop. Notice on respondents are complete. Over extra copy to finish. Stop. List the matter after 3 weeks. Along with WBC number
3009/23.
3009 of
2020.
Another
Where-
matter is of same, your lordship.
where for entry shall be considered on the next returnable date.
Lordship,
Another is,
my only anxiety is lordship. Let her then make a statement which will not fill up the post. Let her make that statement.
Are you taking up the post or not?
your lordship,
At
next
least
week,
because-
your lordship, let the notice, next date, your lordship, it may consider, your lordship.
May consider.
Next
That's why, before that, are you going to fill up the post?
Your lordship,
That also.
that will communicate, your lordship, but
Fair.
not to consider, your lordship. Let it considered on the next date, your lordship. Will obtain instruction.
Let there be
Deeply
some
obliged.
restraint, lordship. Otherwise, my writ petition,
lordship.
lordship, I have been able to make out
Are
the
you
case.
making a commitment that you are not going to fill up the post?
Your
That will
lordship,
be recorded, lordship.
I cannot do that, your lordship.
Then lord
We-
will pass an imprimatur.
I cannot
Then
do
I'll
that,
pass
your
it on.
lordship.
Then please pass an order.
Lordship, let it considered on next date, your lordship.
Till the next
On a-
returnable date.
Or your lordship take it at 2, your lordship. Matter may take it at 2, your lordship. Let my senior be appear in this matter.
Okay, where's your seniority?
Senior, lordship. 1, 2, no.
11 and 12, your lordship.
Lordship, can there be a little accommodation if can it be made the last item before lordship rises before lunch? Because I have a little
At
difficulty.
2, your lordship.
Can you get hold of your senior?
No, your lordship, he is on leg, some urgent matter is.
No, I'm
Your
saying the last matter before lordship
Oh.
rises for lunch.
as
That is
last.
just before the lunch break.
Yes, your lordship. Let me check. Deeply obliged.
So before lunch break, lordship, I'm in some difficulty. Wait for lunch.
39 order.
May I respond?
Yes,
My lord, the director, the ex-director is before my lord.
yes.
No, my lord would see the matter, my lord, because what exactly was the direction? The lordship would come to page 10.
That I've seen.
My lord, the direction is not to the pension department, my lord. Here under 143, the requirement is, my lord, that the appointing authority, the head of that office, will give a certificate that this person is disabled basing on medical documents and that he is not fit to earn a livelihood. Without that certificate coming on board, my lord, no authority can do anything. My lord. They have not even made the education department a party. None of the authorities of education department is a party. This man retired in 2018. And before his retirement, my lord, he had highlighted all these aspects to the district elementary education officer.
Where are the documents? That's
My
what
lord,
I'm
yes,
asking.
my lord. And the direction, my lord, would find that paragraph, page 10, last time.
That I've seen.
Absent. And my lord, that boy, whether he is disabled from his birth, he got disabled in between, what is his education qualifications? These things have to be brought on record, my lord. And they have never said that these things have been brought on record.
My lord, this is a consensus order, my
No,
lord.
no,
This
no,
is- This is settled in the local law, my lord.
No, but
This
it's not a
aspect of the
consensus
matter,
order.
they cannot brought in the contempt proceeding, my lord. I'm sorry, my lord. This
Hurry, but there is a
this is
direction there.
consensus
That
order
has to
in
be
local
complied with.
law, my lord. This is consensus order in local law, my lord. Now they cannot dispute, my lord.
I'm not disputing. I'm only saying the procedure.
My lord, I am praying for my lord, disabled my lord, pension of my father, my lord, not from anyone's pocket, my lord. with due respect to my learned senior, my lord.
No, my lord, let him read paragraph 10,
I have
the
read.
last paragraph, my lord.
But
And if that is complied with-
this gentleman was present in the while order was passing, my lord.
My lord, I'm sorry, the direction of the court is to be looked into, my lord. My lord will come to para 10, page 10, my lord.
Yes.
My lord will have the second paragraph. Mr. Bhavesh Deka, so and so has stated that the pension department is unable to process the claim of the family pension for the reason that the appointing authority of so and so has not stated that his mentally disabled son is a handicap of the nature that has prevented him from earning his livelihood. The director of pension further states that though an appropriate certificate as regards disability has been issued by the joint director of so and so, but over and above the said certification, the satisfaction of the appointing authority as provided under Rule 143C24 is also required. The concerned officer of the education department has stated that some proposals have been forwarded by the DEO, but the same has not ultimately not materialized. It is stated that the appointing authority is the director of elementary education Assam. Now, my lord will see. Accordingly, it is directed that the director of elementary education Assam shall give due consideration to the disability certificate issued by the joint director of health services Kamrup Amingao and pass an appropriate order under 143C24 and state his satisfaction that so and so being a handicapped person is unable to earn his livelihood and that the nature of his handicap is that he is prevented from earning. The said order shall be passed by the director within a period of 15 days from today. That director is the director of elementary education Assam. My lord, that order has not been passed till now, till the date Mr. Deka was in office, my lord.
Who is the director?
He is the ex-director, he retired in 2018, man. The whole case of the petitioner, my lord would see, even in the paragraph, they have made reference to this in paragraph 8, my lord.
Who is respondent number 2?
But the respondent number 2, my lord, died, my lord.
He is also my director of pension. The director of elementary education has to come up before my lord and
Director of
say
elementary education is respondent number 2.
they have made it subsequently.
My lord,
Yes.
in contempt application, my lord, Mr. Sanjeev Kumar Bhuya was there, my lord, but subsequently he died, my lord.
Okay.
Have you impleted it?
But I have to impede, my lord.
Then-
It did new
Does the-
income.
does the
Why, my lord, just unnecessary harassing a person, my lord,
No,
here by
no, 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 no. I am not pressing this, my lord. I am pressing that, my lord. Last order, my lord, while my lord matter was listed before his lordship Surana, my lord. That, my lord, he was unrepresented, my lord. That is why honorable court said that bring him personally, my lord, because there was no representation on behalf of the minister Bhavesh Dega, my lord. That is why he was
already retired, the new
My
person.
lord, kindly lordship see the last order, my lord.
Yes, true, man.
That I've seen.
My lord, that is why I will, my lord, bring on record this, my lord, in new incumbent of the, my lord, elementary education.
Okay.
But, my lord, as, my lord, Bhavesh Deka was unrepresented, my lord. That is why he was, my lord.
You are Mr.
I am TK Bhuya, my lord. My lord, my learned friend, my lord, apprised me, my lord, there was a communication, my lord, on 16/3, my lord, that he, my lord, within a 1 month, my lord, he will, my lord.
No, my lord will let the director come up and say that he has.
My lord, he is representing Mr. Bhavesh Deka, my lord, not Ranjan Bora, my lord.
Mr.
Why my rather senior friend is, my lord, my TK Bhuya, my lord.
We are learned counsel for the petitioner. The respondent number 1 who was directed to be personally present is present today. Stop. It is submitted by the respondent number 1 that he retired on
My lord, he retired on
39 to the
30 September 2018.
30 September 2018. And before his retirement, as the respondent number 2, who was supposed to pass the order as per the direction of the Lok Adalat
Lordship.
dated 9/9/2017, has taken no steps. He could not proceed any further in the matter.
Lordship.
At this stage, learned counsel for the petitioner submits that the respondent number 2 has passed away
My lord.
in the meantime, and therefore he prays for some time.
One week, my lord.
Prays for. Have you given notice to the
That is, I mean, within 1 week, my lord, I will send a place the order before him, my lord. Thereafter, I will.
2 weeks time. To enable him to file an appropriate application for implementation of.
My lord.
Considering the submission made by the relevant council for the application. Price allowed, list the matter after 2 weeks. The personal attendance of the respondent number 1 is dispensed with.
Multiple.
But one more submission, my lord, this Rondon Bora was, I have filed an IA, my lord. He was implemented, my lord. My lord, what is the, my lord, I checked, my lord, Edika received, my lord. Perhaps, sir, he is
One of
appearing.
my friend has filed an wakalat.
On 26/5/23. I have
Yes,
already
fine.
filed.
He is appearing, my lord.
So let him furnish a copy of the
Let him
contempt
file
petition to me.
Let
That
him
he-
come out. You
yes.
first file your implementation.
My lord, my lord. Deeply obliged.
Oblige, your lordship.
14, motion.
Lordship, perhaps the presence of the petitioner, the contemptor is being dispensed with your lordship, as he has made his appearance today.
Have you heard what this order passed? What this court?
Pardon, your lordship.
What order was passed?
Pardon.
Yes.
May I please? What's a matter relating to a PT issue is because lordship due to
What issue?
issuance of non-royal statement lordship to the petitioner's lordship by the headmaster lordship, that is Dokhin Kamrup High School lordship, to the present headmaster lordship, despite having repeated instruction by the inspector of the school lordship as well as the honorable high court lordship. Can you please lordship page number 37? Page number 37 lordship, annexer J lordship.
Yes.
This report has been prepared by the inspector of school lordship itself, and same has been submitted before the learned standing council lordship in pursuance of the contempt case number lordship 779/19 lordship. Here lordship the stated that lordship the inspector of school also instructed to the headmaster of Dokhin Kamrup High School, who is the respondent number 6 lordship, to submit the non-royal statement lordship to the petitioner's lordship. That is why lordship my pensionary benefit has yet to be held up lordship, as well as the pensionary benefit and entire lordship gratuity, GPF, etc. lordship. Only for this ground
Will
lordship.
the order passed by this court?
Your lordship has your lordship order dated lordship 22/7/2022, annexer F, page number 27 lordship. Page number 27 lordship. Whoever directed to the respondent authority lordship to disbursement of my pensionary benefit lordship within a period of 3 months lordship. But non-compliance of the said order lordship as aggrieved lordship, I have filed another contempt petition lordship, having contempt case number 779/22 lordship.
Where is that?
That is the page number 32, annexer 8 lordship.
Then
Whoever lordship this court has directed to the inspector of school lordship to constitute a committee lordship and inquiry lordship whether any I have a liability to furnish to the headmaster lordship. But finding lordship stated that I have no any liability lordship, including all aspect lordship, as well as financial and all aspect lordship. That is also reflected lordship annexer J, page number 37. I have already draw attention before your lordship, page number 37 lordship. And the relevant portion is the page number 38 lordship. That is the last portion lordship. Can we please lordship? the photocopy of unutilization certificate of the period have been provided to the present headmaster, that is Midul Kumar Laskar, during the discussion on 2/5/2023, and he was asked to issue NOC to Sri Gokul Bora, the petitioner, Lord, and the petitioner, Lord.
Then what happened?
So, Lordship, yet to be, the headmaster has not issued the non-issuance of liability, Lord. Dual statement, Lordship, to me, Lordship. For which, Lordship, my pensionary benefit has been held up, Lordship.
What happened to the contempt?
Contempt is yet to pending, Lordship. Yes, Lordship, I have a minor 2 children, Lordship, 2 child, Lordship. And even my provisional pension has been also held up, Lordship, as because 2 years has already been over, Lordship.
Yes, who appears?
This is only a Westminster part of the headmaster, Lordship.
Headmaster notice has to go on.
My lord, it is costly it is reflected as standing council elementary, my lord, but it is case of secondary, my lord. So
Secondary education.
yes, my lord.
You are appearing for secondary?
No, my lord.
Who appears for secondary?
SM60 is there, my lord.
Who is he? But the headmaster has to answer this petition, isn't it?
Yes.
Hand over.
Chishti,
In possibly it is shown as elementary, that's why we have missed this item, Lordship.
issue is this on page 38. The third class paragraph.
As per these. Oh, this matter, Lordship. Gokul Bora. Oh, yes, yes. I think Lordship here. He was supposed to. Yes, Lordship. The petitioner was supposed to submit some non-liability statement, Lordship.
That he has submitted.
Yeah, that he has submitted. Now that
No,
person who is holding the,
no objection certificate has to be issued by the headmaster.
that is not issued, Lordship.
That is not issued.
that is
That's
not
why
issued.
he's suffering.
Yes, yes, yes. I remember this.
You are getting a provisional pension.
No, no,
Is it
no,
dispute
no.
between that?
Provisional pension has already been held up as because Lordship 2 years has already been passed over, Lordship. That is why.
His grievance is not against the department, against that earlier headmaster who is holding the share, Lordship. He is not releasing. That is
I think Lordship.
What is this headmaster doing? Despite orders passed by this
yes,
court.
Lordship. He was even given personal appearance in this court also in a contempt proceeding, Lordship. He has appeared personally also, Lordship. Even then, Lordship, he is not releasing. And he has not been made party. He should have been made party in this petition, Lordship.
Is there a party?
No, Lordship.
Yes, sir.
I
Now
remember
we
in a
have made
contempt
a party,
petition,
Lordship.
Lordship, the headmaster was personally directed by this honorable court to appear personally before this honorable
Yes,
court,
Lord,
Lordship.
earlier dated headmaster was personally paid, but he stated that due to the petitioner has some liabilities, Lord. He stated that before this court also. Therefore, this court has directed to the inspector of school, Lordship, being a competent authority, Lordship, to inquiry the entire aspect, Lordship, and submitted the report, Lordship, before the court, Lordship. That is why, Lordship, the present report has been prepared and same has been submitted before this court.
And inspector report says that the Gokul Bora has no liability pending in the school.
Yes,
Page,
absolutely
that
right,
is- that I have
Lordship.
seen,
In any way, Lordship, I have.
page 38, last para, Lordship, second last para.
Yes.
After inquiry, inspector school, it is revealed that from the above facts that Sri Gokul Bora has no liabilities pending to the school in all aspects. Even then, Lordship, that earlier headmaster, he is not releasing, Lordship. He should have been made a party in this petition.
He's a party.
But not
Yes, part you made and
As
part.
a headmaster, yes.
So Lordship, I think Lordship, the inspector of school also competent authority Lordship to issue non-liability certificate Lordship.
No, that will be
Instead of the
issued by the headmaster. Inspector can
direction
also
may
look
be
it.
given.
Headmaster has to issue the certificate.
Yes, yes.
Yes.
Now we can't pass any direction in the absence of headmaster.
Yes, Lordship. Let him take a dusty notice, let him take a dusty Lordship.
Dusty service.
Lordship may
Justice,
fix,
sir. Lordship, permit.
Heard Mr.
M. Cycle.
Cycle and council for petitioner. Issue notice. Mr. S&T Chief Still and expanding council secretary.
1, 2, and 5, Lordship.
Education affairs correspondence.
2 and
1,
5.
2 and 5.
I appear for respondent number 3.
And Mr. G. Bikul, government advocate.
My lord,
Appears for respondent number 3.
I appear for 4.
And
R.
Mr.
Ahmed.
R. Ali.
R.
R.
Ahmed.
R. Ahmed, standing council, accountant general appears for respondent number 4. Stop. Considering the urgency involved, petitioner is permitted to post service of notice on respondent number 6 by dusty service to the registry of the spot within a period of 1 week.
Yes, Lord.
Draft the petition and file an affidavit to that effect. Reach the matter after the summer vacation.
Highly appreciated. Lordship, can you make this matter Lordship along with the contempt case number Lordship 779 of.
We'll see, let it come up first.
Highly.
15.
May I please, Your Lordship.
Yes.
This case, Lordship, I have challenged the amalgamation order. Lordship will find it annexure 3 page 22. Lordship, case of the petitioner is that Lordship petitioner school is a girls' school situated in the district of Sibsagar, my lord. And it is the only one girls' school of the locality, Lord, my lord.
Page.
That is, Lordship, amalgamation order is annexure 3 page 22, my lord.
Yes.
My school name is Namti Girls High School, and the amalgamated school is Namti Boys Higher Secondary School. And it is the base school of the locality, my lord, Namti Boys Higher Secondary School. And that this amalgamation, I've challenged, Lordship, this amalgamation order is violation of office memorandum that Lordship will find in page 24. Clause 7(1). Because my school is a totally different school situated separately, separate building, separate land, separate infrastructure. But this OM 7(1), my lord, made it, my lord. All the schools situated in the same campus shall be merged with the highest level school in the same campus. Our school is totally different school. Our school is girls' school, and that is higher secondary school. And our land is infrastructure, whole building is different, separate. And this higher secondary school is totally different. So this is also clear violation. And my lordship, prior to this amalgamation order, lordship will find in page 33, that is annexure 5. The advisor of the Honorable Education Minister already issued one notification wherein total 18 numbers of school of the state are going to declare as Adarsh Vidyalaya. And my that notification serial number 5, that is Adarsh Vidyalaya Amguri, previously known as Namti Balak Ushchatar Madhyamik Vidyalaya, that is Namti Higher Secondary School, that is already converted into a Adarsh Vidyalaya. So our school is girls' high school, and this is also clear violation, lordship. Without going to that, or amalgamation order is already issued. And to that aspect, page annexure 5, page 33, one advertisement also issued, and admission also going on.
Only difficulty is also that amalgamation has already been taken place on 23/5. That process has already taken place. The petitions will come earlier before the amalgamation.
My lord, I have stated specific
now,
statement that amalgamation order we have received only on 13 June.
Lordship may issue notice. Let me take instruction, Lordship.
13 June only we have received that amalgamation order.
That amalgamation has already been done, Lordship.
So we have received the priority are already done. We have come to know knowledge only on 13 June. That is why we prefer not any appeal.
Better case than he will.
Has the school been amalgamated?
Yes, yes, already been 23/5/23 last month, Lordship.
We have not received any kind of such order, lordship. Only we have received that amalgamation order only. That whether it is already amalgamated or not.
Yes, on 23/5/23.
What about clause 19? of the OM.
That is their lordship. They have not done that lordship. Page 32.
Lordship, that is, I know, Lordship, Director concerned will issue necessary order for amalgamation for any dispute arising out of their, so may appeal, prefer appeal. Lordship, I have stated, Lordship, because time was too short, we have received only on 13/6. That is why we could not prefer any appeal, Lordship.
Has it been amalgamated yet or not?
Yes.
Has your school been amalgamated?
As per my information, no amalgamation. is there.
23, 523 is
Then let there be status quo as on today, let them file the appeal.
Lordship, may
let them
stay that notification because I have,
better process.
in that
It
case,
has already
Lordship,
been amalgamated,
I have
Lordship.
one similar case, Lordship. In that case, Lordship has stayed that order.
Even then,
I
lordship,
am also
here
present.
lordship, the amalgamation.
You are not in a position to say whether your school has been amalgamated yet, despite the order.
As per my information, not
According to
amalgamation.
that, that's why I'm saying the status quo as on today will be maintained.
Lordship, as per my information, Lordship, there is no amalgamation, though that order was passed.
You have to come with a specific statement, not information.
And my information, the amalgamation has already been done.
Lordship,
So let
if
the-
officially that amalgamated, that status quo order will affect us, Lordship. So that stay, Lordship, for the time being, Lordship, let them file affidavit.
How do I stay when this court is not aware whether the amalgamation order has given effect to?
Lordship, I'll obtain it after some time, my lord.
Why after some time? All cases are going after some time.
No,
after some time.
It is the better way with they should have file appeal before the director, lordship. And on that ground, lordship may kindly dispose.
If it is already amalgamated, there's no point of issuing a stay order.
Lordship, but
If I pass a status quo order as on today, if it is not amalgamated, it will not be amalgamated. If it is amalgamated, it makes no difference to you.
Lordship,
Then, so you file your appeal.
Lordship, as per my instruction, Lordship, till let no amalgamation. is
That's
there.
why.
Yes, Lordship.
Status quo is on today. Heard Mr.
R.K. Talukda, my lord.
R.K. Talukdar, learned counsel for the petitioner. Also heard Mr. S.M.D. Chishti, learned standing counsel.
Lordship, lordship, may I pay one thing, lordship?
Yes.
May I have a instruction from the inspector school chief secretary, lordship? Lordship, may can take it after 10 minutes, lordship. I'll take whether amalgamation is done or not. From the district, I'll take the instruction, lordship. I think instruction, the amalgamation has already been done. Let me take a telephonic conversation with the
You're
inspector.
saying amalgamation has not been done.
Then I'll take it from the inspector school.
No, what difference does it make if I make a pass in a status quo order? Does it affect you in any manner? Then
Either way, lordship.
secondary education, standing council, secondary education correspondence. 1, 2,
1, 2,
3.
3.
4 and 5 I appear.
Mr. D. Bekul and government advocate for respondents 4 and 5. Stop. By this writ petition, the petitioners who is the School Management and Development Committee, Namdi Girls High School, and represented by its president, is aggrieved by the order dated 23/5/2023, whereby the Namdi Girls High School has been amalgamated with the Namdi Boys Higher Secondary School, and the said Namdi Boys Higher Secondary School has been made the best school.
Adarso Vidyalaya. Adarso Vidyalaya.
The school has been already been converted to Adarso
Adarso
Vidyalaya.
Vidyalaya. CBSE affiliated Adarso Vidyalaya, my lord.
I am going according to this order. Stop. It is the submission of the learned counsel for the petitioner that the Namdi Girls High School has been converted to
Not girls, Balam High School, boys.
Boys.
Huh?
Namdi
Namdi
boys.
Boys Higher Secondary School.
1 minute. Where's that order?
Page 33, my lord. Serial number 5.
That the Namdi Boys Higher Secondary School has been converted to
Adarso Vidyalaya.
Adarsha Vidyalaya. Stop. for the case of the petitioner is that the Namdi Girls High School is situated at a distance of about
Lordship, the campus is different, Lordship, though it is nearby.
the campus of the Namdi Girls High School is different
Different.
from that of the Namdi Boys Higher Secondary School. And that what are the other grounds?
Lordship, only one ground is also that is office memorandum violation of
And,
7.1.
and there's violation and the respondents have violated clause 7 within bracket 1 of the office memorandum dated 3rd August 2021 issued by the Secondary Education Department. Stop. Para. Clause 19, is it?
Yes, Lordship.
Clause 19 of the OM dated 3rd August 2021 provides for an appeal before the government in the secondary or elementary education department against any disputes arising out of the order of amalgamation. Stop. Accordingly, para, this writ petition is disposed of, directing the petitioners to file an appeal before the secondary, before the
Director.
before the
Director secretary.
not director, government. Before the secretary
Director-
school education department,
Yes, secretary, Lordship.
school education department,
Department.
within a period of
Weeks, my lord.
2 weeks with effect from today. Stop. Thereafter, the secretary school education department shall consider the appeal filed by the petitioner after giving an opportunity of hearing to both the petitioner school, to both the petitioner as well as representative of the said Namdi Boys Higher Secondary School and dispose of the same by a speaking order and in accordance with law within a period of 2 months with effect from the date of receipt of the appeal. Stop. Till the appeal is disposed of, comma, parties are directed to maintain status quo as on today.
Let me know.
16.
Yes, essentially, your lordship, this relates to the petitioner's prayer for your lordship promotion, your lordship, and your lordship under career enhancement scheme, your lordship. As your lordship, the petitioner, your lordship, in fact, was appointed in the year 1992, your lordship, and your lordship, he's in the meanwhile, your lordship, in 1999, the earlier, your lordship, coming to this implementation of this AICT notification, your lordship, they were under the state government scale, your lordship. The scale and service conditions subsequently revised by the AICT, your lordship, and accordingly, your lordship, they have reduced the promotion to the senior scale, your lordship, the years of experience to 6 years, your lordship. Under the state government, it was 8 years, your lordship. Now, this is, your lordship, made applicable to your lordship. The state government also, state government by an office memorandum has, your lordship, accepted it, adopted it, your lordship. And then what happened, your lordship, there was a clarification by the AICT, your lordship, that this notification will also be applicable to those who were appointed prior to 1996, your lordship. Therefore, I should have come under this notification, and my date of, your lordship, getting senior scale should have been, your lordship, 1998, your lordship, year, your lordship. But, your lordship, that pursuant to that, your lordship, adoption of this by the government, your lordship, page 43 annexure, your lordship, in 2007, your lordship, all the other persons, your lordship, who were appointed along with the petitioners, your lordship, if your lordship comes to page 46, 67, 68, 69, serial number, all of them were, your lordship, given promotion, your lordship, with effect from 26/8 1998, your lordship, on completion of 6 years, your lordship. But so far as your lordship petitioner is concerned, your lordship, that was not granted, your lordship. Then your lordship, there was a proposal, your lordship, in the year 2017, ultimately a file was processed, your lordship will get it at 48. Director, your lordship, wrote to the commissioner and secretary for your lordship, giving me that benefit, your lordship, so that I can, your lordship, get the benefit of subsequent promotions, your lordship. And that has still been pending, your lordship.
Where is that?
Page 48, your lordship.
Yes.
And that they have not taken any decision on this, your lordship. And in fact, your lordship, what has happened in the meanwhile, your lordship, a case was also instituted by some of the persons, your lordship, seeking exemption under the AICT notification. This honorable court has allowed this, your lordship. Now I have come with a prayer, your lordship, since this is pending and no action has been taken, your lordship, and otherwise I am entitled to that. I don't have any claim for monetary benefit, your lordship. I only want that my promotion should be effected from like the others who were, your lordship, similar identically situated like me, your lordship, so that I can get the promotion, your lordship, into the subsequent stage, your lordship. Now, therefore, I am before this honorable court, your lordship. As of now, your lordship, since it is a promotion under CAS, your lordship, career advancement scheme, I don't have any interim prayer also, your lordship. At this stage, your lordship may be pleased to issue notice and let them file an affidavit, your lordship, why they have not. Yes, consider.
Heard, Mr. Yes, Portable and counsel for the petitioner. Issue notice. Mr.
D. Upamanya,
D. Upamanya,
Standing Counsel.
Standing Counsel,
Higher Education Department,
Higher Education, applies for respondents,
1 and 2.
1 and 2.
For 3 letter notice to notice.
AICT, any standing counsel is there?
Notice
AICT,
Okay.
I don't
Extra
know.
copies, so and so. Petitioner takes steps for service of notice on respond number 3 by registered post AD within 1 week. Respondents are not and the respective counter affidavits. List the matter after 4 weeks.
highly of
Deeply obliged.
17.
May I please, Lord. My lord, the service of the petitioner was provincialized, my lord, by Annexure 4, my lord, page 20.
Yes.
The first paragraph, my lord, the Doxin Business Senior Secondary School, Baksa, with effect from 1st January 2021, my lord. School was provincialized. And the name of the petitioner at page 21, serial number 17. Manoj Das, postgraduate teacher, political science, date of joining 1/10/2010, salary 16,200. My lord, but the service of the petitioner, my lord, as his name was not in the dice code, my lord, so there was a process, inquiry was made, my lord, that is the Annexure 6, page 23. The Director of Secondary Education directed to make an inquiry why the persons, teachers whose names not in the dice code are not provincialized. For which their services could not be provincialized, my lord.
Your name was not there.
Not dice code, my lord. So, my lord, the inquiry was
In any case, you were provincialized.
provincialized, but subsequently my service was deprovincialized.
Okay.
That is, my lord, that is the order, my lord, that is page 8, my lord. Deprovincialized on 30 April 2022, my lord.
Annexure 8, page 25.
Annexure 8, page 25.
Which is your name?
My name is serial number 2. Deprovincialized on the ground that my name was not captured in the dice code. This honorable court, my lord, has already decided the issue that in respect of the higher secondary school and junior school, dice code is not necessary, capturing is not necessary. That judgment has been passed. I have quoted it, my lord, in paragraph 18, page 12. And that is the judgment also, my lord.
And the notice should go at this stage, Lordship. Let me take.
Page, para 12, page 18.
Because in the appointment order, Lordship, clause 5 there is a condition that if any information found incorrect or false at later stage, the order of provisional shall be then cancelled immediately. That condition was there in the appointment letter, Lordship. Let it notice go, Lordship.
Yes.
My lord, notice go. And in the interim prayer also for salary, notice will also go.
But Mr. S.
J. Sutia, J. Sutia.
J. Sutia, let me counsel for the petition. Stop. Issue notice. Mr. SMD Chief, understanding counsel.
Actually, respondent one, it is not, it is struck off. There is no principal secretary, Lordship. The secretary school education is a. Anyway.
Yes.
But it was issued, some letter was issued by the principal secretary,
Okay.
so I have made the party, my
Address
lord.
for
At that time,
respondents,
Lordship.
1, 2,
2 and 3.
and 3. All
Now 4 is there for BTC, Lordship. That is,
3. Who appears for BTC?
BTC is not made a party in this petition. Otherwise, my friend, he may appear, Lordship.
I'll make the,
There,
if you lordship allow my, in the before the register judicial and make the BTC as a can.
No, that is not permissible. Notification is out, I think. I don't know whether it has come out or not.
Respondent number 4, he may
You
appear, my
will
lord.
have to file an application for correction of the cost title.
My lord. Respondent number 4, my lord. The
And,
which should be done by the government, not by the BTC.
And Mr.
Yes, Boral.
S. Boral, understanding counsel, BTC appears for respond number 4. Stop.
it actually BTC, right? Provincialization আমি করেছি।
Notice and respondents are complete. Respondents are allowed to file the respective contract levels. List the matter after 4 weeks. Prayer for interim shall be considered on the next written date.
May it please, Lord. My petitioner before Lordship is a specially able person, my lord. He has some 40% disability, my lord, due to locomotor disability. My lord, his father, my lord, expired on 15/9/2012, my lord. Immediately he applied for the post on compassionate ground. But on what happened, my lord, on the respondent number 5, my lord, he has issued a letter, you also will find page 28, my lord, asking the petitioner to appear before him, page 28, Lord, for a clarification, my lord, hearing some clarification. Page 20,
28.
yes.
Oh.
It was dated on 4/8/2014, my lord, asking the petitioner to appear before him, authority, my respondent of 4, my lord. But what happened in the meantime, my lord, by minus dated, your lordship will find page 31, my lord. Even before the hearing, my lord, page 31, minus dated 25/9/2013, the case of the petition was rejected.
On what grounds?
But it says, my lord, page 33. Page 33,
Oh.
third portion, my lord, serial number 4.
Oh.
The case is considered and not selected on the ground of economic condition, which is better than the recommended candidate. Now, who has been recommended, my lord? And how, my lord, the petitioner's case is considered? It was not reflected in the order. There is no consideration of physical disability of the petitioner, my lord.
You have 40%?
40% visible, page, Lords will find page 68, my lord, Annex 10. Certificate issued by the medical board. And there are, my lord, issuance of various office memorandum, my lord, since 1983, my lord. No, none of the, my lord, such office memorandum has talks about, my lord, physical disability of person, my lord, for consideration or appointment on compassionate ground. Locomotor disabled.
Yes, Beko.
But page 33, my lord. There was only one post, my lord, and that name of the recommended candidate. The remarks column, Srimati Karvi Soikya, were found poorer than other candidates. And since she was a widow, her name is recommended. One post So she was given. Other candidates were better economic condition.
How about the petitioner?
Yes, serial number 4, my lord, is written.
He's 40% locomotor.
Yes.
Disability.
For that
Have
part,
you considered that ground?
for that ground, my lord, it's not reflected here, my lord.
Then-
No, my lord. But again, second time, my lord, 2014, my lord, next DLC, my lord, page number 41.
Under the office memorandum, your minutes, your lords will find my lord.
Page,
Page, my lord, 36.
41.
My consideration,
40.
page 41, my lord.
41.
Now they have come up with a different ground, my lord. Page 41, serial number 8.
They have considered a second application. Earlier it was rejected and again fresh application was given.
Kindly have a look, my lord. Serial number 8. The date of latest application is after more than 1 year. From the date of and he is underqualified. Now they said, my lord. The post for grade has applied, so application is considered and rejected. My disability was never considered, my lord, at all by the respondent while considering.
yes.
Then the person who has been recommended, Korobi Saikya, is the widow of an assistant teacher. How a assistant teacher's financial condition can be worse than a my lord Shokidar? My father was serving as my lord Shokidar in concern.
Yes, Begu.
Hello. Sir, let me obtain the instruction, my lord.
What instruction?
Whether that part was considered or not, my lord.
But Mr. PJ Sankar, Learned Counsel for the petition. Mr. G. Begu, Learned Government shall receive instructions as to whether the concerned DLC, while considering the case of the petitioner, consider the 40% locomotor disability of the petitioner. So, list the matter. After
2 weeks.
2 weeks.
19.
May please, my lord. The matter relates to my lord selection and appointment, my lord, for the post of principal in Goreshwar College, my lord, under BTC, my lord. Petitioner before your lordship is an MA in education, my lord, with PhD degree, my lord. And presently she has been working associate professor, my lord, in Goreshwar College itself. And for last 26 years, she has been working there, my lord. Now your lordship will find, my lord, that an advertisement was issued, my lord, on 1/1/23, my lord. At page 22, my lord, your lordship will find, my lord. Page 22, my lord. Second column, my lord, the advertisement for the post of principal, my lord. Principal Goreshwar College against regular vacancy, that is there, my lord. Then you also will see one thing, my lord, clause 10, my lord. That is important. Clause 10. Has you also got, my lord? Clause 10, my lord. It says, my lord, preference shall be given to the candidates belonging to BTR, my lord. And then, my lord, being eligible and duly qualified, I apply for the post, my lord. And thereafter, on 1/4/2023, my lord, academic register Bologna University issued call letter, my lord, inviting me to appear before the interview board on 6/4/2023, my lord. And accordingly, I appeared in the principal selection committee, Bologna University, my lord, and in the selection, my lord, the selection committee, expert committee has awarded, my lord, you lords will find page 24, my lord. Page 24, my lord. They have awarded, my lord, this is average mark, my lord. I have been awarded 61.05 marks, my lord. And respondent number 7, my lord, he has been awarded marks of 57.23, my lord. So I have been given more marks, my lord. And accordingly, my lord, this selection committee has taken a resolution. Next page, my lord. Page 25, annexure D, my lord, at the bottom, my lord. Resolution number 1, my lord. The committee selected Dr. Pratibha Patwari, the petitioner, my lord, for appointment against the post of principal, Goreshwar College, Goreshwar, based on performance in the interview held on April 6, 2023. Further, resolved that the resolution of the selection committee be forwarded to the governing body for its approval and necessary action for appointment. Accordingly, this was forwarded to the governing body of the college, my lord, and governing body of the college, my lord. Next page, my lord, page 26. They took a resolution, my lord, on 16/4/2023, my lord. May I read the resolution, my lord? On today's meeting, 16/4/2023, of governing body resolved to approve Dr. Pratibha Patwari, petitioner, my lord, who has selected as first position by the expert committee of Boroland University for the post of regular principal, Goreswar College. It is mentioned, it is to be noted, my lord. It is mentioned that Dr. Pramod Mehri, respondent number 7, who has secured second position, is a permanent resident of BTR area as per mentioned in the advertisement. So it is very clear, my lord, that this governing body has considered this aspect, that he is a local person of that BTR, my lord. They have considered this aspect. Even then, I have been recommended, my lord. In spite of that, they considered it fully, my lord. They considered, and I have been recommended. And thereafter, my lord, what happened? Suddenly, my lord, this director of education, PTC, has appointed, my lord, respondent number 7, my lord. May I read this order, my lord? Page 27, my lord. Next. In exercise of the authority conferred under provision of Rule 7A, my lord, of Assam College Employees Provincialization Rules 2010, and in pursuance of approval of the Secretary BTC, my lord, such and such, my lord, hereby appointed as this Pramod Mehri, my lord. Pramod Desperate 7 has been appointed as principal, my lord. This order has been passed. Now let us see, my lord, what says Rule 7A, my lord. Do I have quoted, my lord? You lost me. Page is, my lord, 499, my lord. 498, my lord. 498 at the bottom, my lord. 498. Has it also got, my lord?
Yes.
Yes, my lord. Rule 7, direct appointment. A is important, my lord. All appointment, either by direct recruitment or by promotion, shall be made by the director on the basis of recommendations of the governing body, based on the recommendations of the selection committee, departmental promotion committee duly constituted. But here in this case, my lord, I have been recommended by the selection committee. Then I have been recommended by the governing body as required under section 7A, my lord. So I fulfill this criteria condition, my lord. Provision says that he has to be selected by the selection committee, then governing body. Governing body's recommendation must be based on the recommendation of the selection committee, my lord. I fully fall under this provision, my lord. In spite of that, my lord, director has appointed this, my lord, as 7. But here, director, what director can do, my lord? Director has got no other power, my lord. He has to follow this provision, my lord. And he has himself, at the very beginning, written, he has followed in exercise of power authority given by this rule, my lord. He has appointed that person, my lord. Though he has said that he is following that rule, but he is doing just the contrary, my lord. So, my lord, in my humble submission, he has violated this rule, my lord.
Let us see what the director says, because already there is an order of this court.
My lord.
It says the director is not a rubber stamp.
Yes, my lord. That is true, but this rule,
While interpreting Rule 7A,
my lord.
this court has already held, correct?
But even though it is very clear, my lord.
It is clear. Let's see what the director says.
At this stage, notice may go, madam, because the order was of 10 May 2023, and by the time the respondent 7 has joined. So within 15 days, he has to join that particular order.
But Mr. Smukta on the counsel for petitioner.
It's a clear violation, my lord. My prayer is maybe state, my lord.
No. Issue notice. Mr. S. D. Upamanyan, and the standing counsel. Higher education appears for respondents.
One.
Only one.
Only one, Lord.
One.
I appear for
Mr. Goral and the standing counsel. BTC.
3 and 4.
For 2, 3, and 4. And Mr. G. Bekul and government advocate for respondents. 5. Petitioner takes steps for service of notice on respondents.
6 and 7.
By registered post AD within 1 week from today. This is the matter of 4 weeks. The appointment of the respondent number 7 shall be subject to the outcome of this petition.
Obliged.
53 of supplementary.
Motion.
Lordship, here in this matter, on the previous occasion, I was directed to obtain instruction, Lordship. Lordship, we have furnished the report to the elementary education, Lordship, since they are the appointing authorities, Lordship. So, Lordship, now it is the elementary education, Lordship, who will have to get the. They are the appointing authorities, Lordship.
My lord, the petitioners.
My lord, kindly fix on Friday, I'll take instruction in this regard. Because on that last day, held was Friday. Fix on Friday, my lord.
Okay, let him take.
My lord, can you see one thing, my lord? Page 25, my lord. Disability certificate, disability certificate, my lord. Page 25, relevant, the above condition is not likely to improve. Meaning thereby, my lord, the petitioner's disability has not been changed, my lord, cannot be changed. So as per rule 18, my lord, of the right of persons with disabilities.
Where's that you're reading?
My lord,
It's not likely to improve.
yes, my lord, it is.
Okay,
Page
let him
25.
take the instructions and come back. Mr. R.S. Chavan and the council for petitioner. Mr. J. Biku, on request made by Mr. J. Biku, Leonard Standing Council,
Elementary.
Elementary Education, list the matter on 23rd. No. 23rd, to enable him to receive this.
Oblige.
54.
May it be your motion. The writ petitions, my lord, two in number, my lord. Number one is a group of institutions, my lord, wherein they have been running Institute of Nursing, Paramedical, and Allied Health Services. And respondent number, petition number 2 happens to be the principal, my lord. What happened in this case, my lord? Respondent number 4, my lord, which is a registered society and which has been this under the respondent number 1 and 2, my lord. And they used to float, my lord, tenders with regard to sponsorship of certain students for their education purposes. Now, this respondent number 4 floated an advertisement for that particular sponsorship, and these were published in some newspapers, my lord, though that doesn't have wide publicity. Accordingly, this writ petitioner didn't came to know about it. So accordingly, after coming to know, it was too late. And so they have written to the government, my lord. Government interfered with regard to this. That is at last annexure, my lord, will kindly see. Page 76, my lord. This has been written to the government, my lord, page 76, and this was the order. After this order, my lord, they have withdrawn this particular tender notice, my lord. As because we have written to the government, my lord, what they did, my lord, they issued a letter to us as stating that in 2022, my lord, they sponsored, my lord, this respondent number 4 sponsored 10 students, my lord. And according to them, they have received complaint from some girl students, my lord, 18 numbers, that the principal that I have demanded. I am respondent number 1, petition number 1 is the juristic person being represented by the executive director. And this is a registered public charitable trust. And he is the executive director of that particular, my lord, trust. Now, it has been alleged in this letter that this I have demanded 10,000 for issuing post-completion certificate. The moment it has been issued, my lord, I give a detailed reply that no, this is wrong. I have never been never asked or met all these girls. It is the principal who didn't ask for 10,000, but asked for 3,000 for completion certificate. In case of Assam and other institutions, my lord, they ask for 3,000 rupees. And that is for, my lord, for registration fees only. We don't charge registration fees as because it is charitable trust. So 3,000 on completion of this one. And there was an agreement, my lord, between respondent number 4 and this particular petitioner number 1, wherein there is an arbitration clause also that the students they have sponsored, my lord, wherein if there is any dispute that can be sorted out by way of arbitration. That is in clause 11 of that agreement. Now, after my written reply, my lord, all of a sudden, my lord, not only one institution, all institution has been blacklisted at page 66, my lord, in Delhi. Now, this has been, my lord,
the impugned order. Now, my lord, thereafter we file a representation, my lord. May I read it, my lord? Typed copy is at page 67, my lord.
Yes.
A certain allegation regarding demand of money of course or completion and registration fees by so and so submitted by students sponsored by Assam Minority Development Board for ongoing nursing course ANM in the above institution. The demand for money is against the condition of MOU signed between the Assam Minority Development Board and the said institution. And an inquiry into the complaint was conducted by the Welfare Minority Development Department, Government of Assam, whereas the complaint was found to be true. The government letter number so and so board for taking strict action against the said institution, whereas the matter was placed before the annual general meeting of the board and a resolution was taken in the meeting to blacklist so and so school of nursing of NEPNI group of institution and any other sister concern where so and so executive president of the NEPNI school of nursing so and so is involved. Whereas the above said institution is declared blacklisted for participating in any work relating to Assam Minority Development Board. Now, this impugned order has been passed, my lord. What is the complaint? The copy of the complaint has not been furnished. What is the inquiry? That has not been furnished. Nothing been done. All behind the bar, behind my back. So after filing of these writ petitions, my lord, they have passed their order, my lord. That's what I am communicating to this honorable court. Wherein, my lord, after going through the writ petition, the awardment, they found it that it is beyond the provisions of law. Wherein, my lord, blacklisting is altogether a different footage and footings, my lord. They unilaterally withdraw that particular, my lord, blacklisting order. And they state in this order, my lord, due to unavoidable circumstances and declaration of blacklisting as earlier issued by Assam minority so and so, 1st June against so and so, against the NEPNI School of Nursing, a unit of nursing class under NEPNI group of institution is hereby withdrawn until further orders. In that view of the matter, my lord, may I submit, my lord, that this writ petition may be closed with a liberty to come again, my lord, if cause of action arises, my lord, if they take any steps, my lord. That is my respectful prayer, my lord. Because these facts are very important. Under what considerations I write to the authority with regard to publication of tenders. Now, I objected to it because in one newspaper where it is not been duly published. Government interferes. They come with a cock and bull story, my lord.
Heard Mr. Gabayan on the counsel for the petition. Stop.
I am for respondent number 6, Lordship. No, 6. It is 5, Lordship.
Also heard.
6 there, sir.
I appear for 1, 2, and 3.
Mr. Joy Bakul and the government advocate for respondents 1, 2, and 3. And Ms.
D. Bora,
D. Bora, standing counsel,
Standing Council for Health and Family Welfare Department.
Health and Family Welfare Department for respondent number 6.
6.
Stop. The present petition has been filed by the petitioners against the declaration of listing, declaration of blacklisting of the said institution, dated 1st June 2023, issued by the Director, Assam Minorities Development Board, on the ground that no copy of complaint was given to the petitioners, and that what was the other ground, and that
My lord,
no copy of the complaint was furnished to you,
not even complaint, no inquiry report,
and,
nothing. my lord.
nor the inquiry report, as well as the inquiry report.
Copy of the complaint.
That copy of the complaint and the inquiry report has not been furnished.
And apart from the notice to blacklist, that show cause mileage is not there.
And as well as the show cause notice to blacklist the institution has been given to them. Stop. During the, in the meantime, after the filing of the present petition, the Director, Assam Minorities Development Board, has again issued an official order dated 15 June 2023, whereby the declaration of blacklisting issued by the Assam Minorities Development Board dated 1st June 2023 against the Nepni School of Nursing and the Nepni Group of institutions is withdrawn until further orders. So, voila. Learned Counsel for Petition and therefore submits that he may be allowed to withdraw this petition with liberty to file afresh if a fresh course of action arises. So, accordingly, the petition is dismissed on withdrawal with liberty as
Disposed of on withdrawal, my lord.
doesn't matter. Dismissed on withdrawal with liberty as
Yes, deeply obvious.
the office order dated 15 June 2023 is placed on the portal.
Problem.
Of Delhi. My lord, in this matter, my lord, original record was called for, my lord. The from the yet to receive, my lord. Kindly pick, regarding school managing committee.
I have also received affidavit on 6th of this month, my lord. I need 2 weeks time to reply.
Yes, Mala.
In
I have
the
also not received the
petition
record.
or in the IA?
In the writ petition, respondent number 2.
What about the IA?
Last occasion, my lord, the honorable court decided to dispose of the entire matter, my lord, and directed to file it.
When last occasion, there's no.
May I submit one thing, my lord?
Yes.
After 2 weeks.
My petition is filed, IA is filed for vacation of the order in past with the petition, my lord. My petition was filed on 25/5/2022. So my lord, kindly take note of Article 226(3), my lord.
Have you filed this under Article 226(3)?
No, my lord.
Well, Article 226(3) comes into play only after filing of the petition, my lord.
No.
Lord,
my
my
kindly see the provision, my lord.
submitting this.
Well, kindly, for a moment.
See your cost title.
Is always, my lord, he's submitting like this. There is no Article 226 in the cost title.
Have you submitted, have you filed this application under Article 226?
For a moment, kindly come to the act, my lord. Provision, my lord.
Before coming to Article 226(3), I want one answer from you.
My lord.
Have you filed this IA under Article 226(3)?
I cannot, my lord.
Why?
Because the provision says that it comes into play only after filing of the petition, my lord.
Have you filed this IA under Article 226(3)?
No, my lord. If my petition, I file my petition, if within 14 days it is disposed of, then 226(3) does not come into play, my lord.
Are you the applicant?
Yes, my lord. I am the applicant herein, my lord.
Then
the 14 days period is counted from the date of filing of the petition, my lord.
Correct.
That is why if within 14 days your lordship disposes of this petition, then 223 does not come into play, my lord. That is why I cannot mention it here.
In your application,
Yes, my lord.
you have to make your application under Article 226(3).
I cannot, my lord. My lord, kindly see the provision for a moment, my lord.
I have seen. Yes. Heard Mr.
S. Alim.
S. Salim, learned counsel for the applicant. Also heard Mr. M.R. Khandakar, learned counsel for the petitioner in WBC 6131 of 2021. Stop. Mr. J. Deku, learned standing counsel, elementary education, submits that he is yet to receive the reports and request for some time to enable him to do, enable him to produce the same. Stop. Mr. M. R. Kandagal, counsel for petitioner, and all, oh, okay, that much will do. Stop. Praise the Lord, list the matter after 2 weeks.
My lord, date may be fixed, but
After spring, summer vacation.
does not come, my lord, in
You
the
can make,
regular course.
you can make your patch.
Oblige, my lord.
55 of supplementary leave.
In this case, the record was called for to verify whether any hearing was taken place after the order. The background is that in the first round of litigation, I have challenged the selection process of the respondent number 5, applicant. That the selection process was not proper. Rather, the marks were given beyond the notification by which it has to be allotted. So that case was disposed of with consent of both the parties, saying that the process should come to an end. And taking into note of my objection, that was fine. Now, thereafter, the authority has passed an order appointing me as the principal and rejected his claim, saying that his BH certificate is not valid because the institution from which he has obtained the degree is not recognized. That was challenged by the respondent before this court, and thereafter the matter was remanded back with 2 directions. Firstly, to verify whether his BEd degree is valid or not, and if the order is in favor of the applicant, in that case, a hearing should be given to both the parties and decide the matter accordingly. Now, they have issued a notice on 21/2021. That is for the purpose of the verification of the BEd degree. And thereafter, on 9/3/2023, the authority has accepted that, found that the BEd degree granted to him is valid. And by the same order, without giving me any opportunity, my appointment was cancelled and he has been appointed. So that is, I have challenged before this court. Initially, status quo order was granted. They have filed this application under 226(3). Matter came up on 9/3/2023, and your lordship has held that the record will be necessary and also observed that the 226(3) effect will not be there. Accordingly, matter came on 16th, that the record has been found by the government, and it was replaced where to see whether after 9/3/2023, any opportunity of hearing of I was heard in the matter.
The record doesn't reflect that after 9/2/23, lordship. That is the mean, I don't know, lordship, whether.
My lord, I'll satisfy your lordship as to what the direction was, my lord.
Yes.
If my lord can come to page 28 of the writ petition, my lord. My lord, his order of appointment as principal was challenged by me because I was at serial number 1, he was at serial number 2, be that as it may. My lord comes to page 28. That is the order passed in WPC number 3558/2021. 11/8/21. My lord has got it.
Yes.
My lord would see in the first paragraph, the last line, my lord, last words towards the left, second line, SN Sharma, learned senior counsel for the respondent number 6. So he was represented before this honorable court in those proceedings, my lord. He was respondent number 6 there, the petitioner before, my lord. Now, my lord, after hearing the parties, your lordship would come to page 30, para 11. The contention of the respondent number 6 therein, madam. So and so for the respondent number 6, on the other hand, contends that the decision of the government while granting approval under section 13(5) is the right decision, and the respondent number 6, upon being appointed, had in the meantime assumed the charge as principal of Bamundangra Higher Secondary School. We take note of an earlier decision, so and so. So, my lord, these were the only contentions raised in that writ petition. Now, my lord would come to page 31, para 13, my lord. From the said point of view, we deem it appropriate to remand the matter back to the approving authority in the government under section 13(5) of the Act of 2003 to verify from the records as to whether the Barpeta BT College has made its application for recognition to NCT prior to 18/8/97 or subsequent to it, as provided in the judgment of this court in Pranita Sharma. The appropriate authority shall specifically call for the records of Barpeta BT College as well as from NCT to arrive at a factual satisfaction as to on which date the college made its application for recognition before NCT, depending upon the materials that may be appropriate order be passed. My lord would have 15. If the order to be passed by the approving authority in the government is in favor of the petitioner for the purpose of other consequential action that would be required to be taken, both the writ petitioner and the respondent number 6 would be given an opportunity of hearing to put across their respective cases till the approving authority takes its decision and thereafter consequential actions are taken. The respondent number 6 so and so shall continue to remain as such. His further continuance would remain upon the logical outcome of the process as indicated above. The approving authority under 13(5) to take its decision within a period of 3 months from the date of receipt of certified copy of this order, and thereafter the consequential action to bring the process to its logical end may be followed. So, my lord, the matter that was remanded back was for, my lord, whether the B.Ed degree is valid or not. For that, a hearing was given. And, my lord, we both were invited for that hearing. We both went there, my lord. We were heard. He also submitted his objections. Thereafter, on confirmation of the facts, the court came to the authorities came to a conclusion that yes, he is, my lord, eligible. That B.Ed degree is valid. And accordingly, my lord, the order was passed in my favor. Now, my lord would see the writ petition, my lord. In paragraph my lord, paragraph 7, page 10. My lord.
Yes.
My lord, para 7. The petitioner begs to state that thereafter, in pursuance to the order of the Honorable Court in so and so, the petitioner was called for hearing by the secondary education, and the petitioner had submitted all supporting documents in their favor. Thereafter, my lord, there is nothing to show in this writ petition that he was, my lord, supposed to be given a further hearing. This came, my lord, in the order, my lord. That is impugned before your lordship. Page 24 of the, my lord, sorry, page 18 of the IA, my lord. Order passed, my lord, which I am seeking vacation, my lord. 8/5/23, my lord, page 19.
Yes.
My lord would have page 2, my lord. It is submitted by the petitioner that the order dated so and so of the state government in the secondary education consequential order so and so are not in
Where are you reading from?
my lord, page 19, para 2, my lord.
Okay.
Sorry, my lord. It is my lord. It is submitted by the petitioner that the order dated so and so 9/3/2023 of the state government in the secondary education department and consequential order dated 29/4/23 of the director are not in conformity with the directions passed by this court on 11/8/21, which I have taken my lord through, wherein the petitioner was the respondent number 6. Then my lord would have para 5. The order is quoted of the earlier order, my lord, in 3/5/58. Then my lord, para 6. It is to be noted herein that earlier the authorities in this so and so did not consider the case of the petitioner, private respondent number 6, for the post of principal, as his B.Ed degree obtained from so and so was doubtful, and were under impression believed that it was not in accordance with NCT Act. It is submitted at the bar by Mr. Saikia, senior counsel of the petitioner, that the respondent number 6 is yet to take charge as principal of so and so from him in terms of the impugned order dated 9/3/23 of the state government in the secondary education department and consequential order dated so and so. Prima facie, this court is of the view that the petitioner has brought out a case that the authorities concerned in the secondary education department, without giving him an opportunity of hearing, as well as the present respondent number 6, passed the impugned order as well as the consequential order that was issued by the DSC Assam. But my lord, if lordship comes to the order at page 24, madam. This is the speaking order passed in pursuance of the orders of this honorable court. And my lord, in page 25, because it's the question whether a hearing was given or not. Page 25, my lord. In compliance of the honorable court's order, a hearing was conducted on so-and-so at 2 p.m. in the office of the so-and-so secondary education department, was attended by the petitioner and Majid Ali. Petitioner is me, my lord, in the earlier case. In the said hearing, the petitioner submitted copy of so-and-so, so-and-so, so-and-so. The documents were sent to for authentication, followed by 3 reminders. So, my lord, basically yes, he had some grievance. Earlier, he had approached this honorable court. This honorable court had said that take the matter to its logical conclusion, and in the meantime, also examine his grievances. The department examined its grievances, found that there was a doubt created with regard to my B.Ed degree. So, my lord, he was appointed. Second round of litigation instituted by me, challenging his appointment. My lord, I have shown the order that was passed, 3558. There is no such objections were raised by him. The honorable court limited the issue to only one issue, my lord, that whether the B.Ed degree is valid or not. It is on that point the hearing was given, my lord. Now that order is sought to be dissected, my lord, which, my lord, may not be permitted, my lord, because the issue that was remanded back was the issue of B.Ed degree.
Let us see that order.
Lordship, my lord, would come to 3558 at page, it starts at page, my lord, 28, my lord. My lord would have page 31, para 12 onwards.
Yes.
From the aforesaid perspective, when we look into the decision of the government under 13.5 of the rules of term that the B.Ed degree of the petition is invalid, apparently the aforesaid aspect of the matter was not taken into consideration. Neither the materials on record that are available do indicate that the said aspect was given a consideration by the authorities. From the said point of view, we deem it appropriate to remand the matter back to the approving authority in the government under section 13.5 of the Act of 2003 to verify from records as to whether the Barpeta BT College had made its application for recognition to NCT prior to 1897 or subsequent to it as provided in the judgment of this court in so-and-so. So the issue, my lord, remanded is para 13. The appropriate authority shall specifically call for the records of the Barpeta BT College as well as NCT to arrive at a factual satisfaction as to on which date the college made its application for recognition before the NCT. Depending upon the materials that may be available, appropriate order may be passed. If the order to be passed by the approving authority is in favor of the petitioner, for the purpose of consequential actions that would be required to be taken, both the writ petition and the respondent number 6 would be given an opportunity of hearing to put across their respective cases. This is the interpretation, my lord, which is creating problems. My friend would say, would like to argue that first you pass the order and then there will be a hearing. I would like to argue, my lord, that in the first instance itself, everything is given. He had submitted all the required documents in the first hearing itself. And thereafter, my lord, the decision was taken. But both the repetition and the other will be given an opportunity of hearing to put across their respective cases. Because my lord would see the only dispute that was there was with regard to that B.Ed degree validity matter. And that was resolved by this order in the IA, my lord, at page 24, my lord. And lordship, hearing
and it's really my please
and lordship, lordship, My lord, we'll only have one more document, my lord, page 42 of the affidavit in opposition filed by my friend, my lord, in that IA, my lord, if that is on record. Oh, Ajit Pelguchini, maybe it has not come on record, my lord. I'm sorry. Therein, my lord, he had on 2010-21 itself, on the date of hearing, given all his grievances. It was put forward.
You have to have a conjoint reading of paragraph 14 and 15.
Lordship,
So
Lordship. I got it, madam.
if I were to interpret also, it says that after the authority
Lordship.
gets the report from the
NCT, they'll pass an order, madam.
they will pass an order.
Lordship,
Now, after passing the order,
Lordship,
before passing the order,
Lordship. Before
if-
passing the
if
order,
the authority is going to pass an order in favor of you,
Lordship,
in
Lordship.
favor of you,
Lordship,
then the petitioner, present petitioner and you will be given a hearing.
hearing.
Before
And my
passing
lord,
the-
conjoined hearing, my case was, my lord, that conjoined hearing was taken on 2010-21, wherein, my lord, he,
Where it appears something went wrong. Where it appears something
Lordship,
went.
Lordship, Lordship.
Director called them. Have they hearing?
Entire hearing, my lord.
And then.
Lordship, Lordship.
That's the whole thing.
My lord can then, my lord, if required, my lord, direct them, because that weird issue is now over. Let there be a, my lord, fresh hearing within a period of 10 days or 15 days, my lord. My lord will fix a day. Both of us appear and then my lord will get, but my lord will not expand the scope. It will only be, my lord, in terms of
I'm not.
para 14 and 15, my lord.
I'm not expanding any scope.
Lordship.
Let there be a fresh hearing, Lordship. That will be
14 and 15, my lord. And then let the consequential orders be passed. My lord will only pass that order, my lord. Because there is no point, my lord, keeping it pending, my lord.
Yes.
Because, my lord, one more submission, my lord. Barring para 15, I understand what my lord is indicating. My submission may not be correct, my lord, to that extent that on that first day itself, the whole hearing should have been done in terms of para 14 and 15. My lord may remand back the matter, but it should be in terms of, my lord, not beyond 14 and 15, my lord. My lord, 13 to 15 is the, my lord, directions given in the earlier direction. If that is not followed, my lord, let it be followed. But my lord, let there be no further additions to that. That much only my submission is. This is my position.
Anyway, my lord, first order he is praying for, my lord. But otherwise, my lord, my grievance in the first instance when I approached this court is with regard to the selection process. I said, my lord, the marks that have been awarded to the, my lord, applicant is not according to the, my lord, notification under which, my lord, the parameters have been laid. That was my grievance. I did not have the grievance with regard to the BEd degree, etc. at that time. Now the matter has been remanded back. Authority did not consider all those aspects. Rather, they found that his BEd degree is not valid. So therefore, his appointment was set aside, and I have been appointed. Now, considering all the aspects, my lord, the order has been passed by this court in twofold. Firstly, you verify the BEd degree whether it is genuine or not. If it is not genuine, question does not arise because I am already appointed as a principal, my lord, and there is no further, my lord, things to be, my lord, seen whether he is otherwise eligible or not. So therefore, if at all, my lord, after the BEd degree found to be valid, then only opportunity to be given to me so that I can put my case. What is my case is that the selection process was not proper. The marks awarded, the documents are available here, I can show, my lord. The marks, my lord, are given, my lord, access to the, my lord, parameters what has been given by the, my lord, the notification.
Now, if you are going to praise that, then we have to take a hearing on this matter. Otherwise,
My lord will only not.
If you want the Inuko's order to be passed, I can pass it now.
No, no, what he is saying, the confined to the, my lord, this paragraph, my lord, 14 and 13 and 14.
Because this is what this court is also noticing. 14 and 15, and then the director passed that particular order.
And I'll place whatever, my lord, my case grievance I am having against his eligibility. I'll place, my lord, the authority will decide.
My lord, my lord will not go beyond, my lord, that. If because the error is in there, let that be, my lord. Let the director act in terms of 14 and 15, my lord. That's all.
In that case, my lord.
Because my lord says that my lord is interpreting, I can't.
What is it? But in that case, if he's my lord, saying so, my lord, let there be a hearing. I'll project the case that my lord, how the marks have been awarded to him and what is my grievance. And in the first order, your lordship will find it has been clearly said that while deciding my grievance, my representation, that has to be taken into consideration.
My lord may remand back the matter. That's better, my lord. There is no point keeping it here.
Once you have a hearing.
But a hearing, it
Yes, my lord, matter can be remanded. Only I'll place my case, my lord. Whatever grievance I have, my lord, I'll raise before the authority, and the authority will take a decision in the matter, my lord.
My lord would have that para
If he
15
has
that
any
is already
grievance
provided
against
for,
me,
my lord.
He'll submit that.
My lord, that is already there. Para 15, 1, 2, 3, third line, my lord. Page 31. Both the writ petition, the respondent number 6 would be given an opportunity of hearing to put across their respective cases.
That's right.
That's already there, my lord.
Yes. So I'll submit, my lord, representation or whatever, my lord.
The representation is also submitted, my lord, on
Raising my grievance.
2010, 2011 by the 21 by my friend's client.
Okay. Heard, Mr. I'm disposing of the main.
Lordship, lordship.
Heard, Mr. B.K. Saikia, senior counsel, assisted by Mr.
M. Kolita.
M. Kalita, and the counsel for petitioner. Also heard Mr. S.M.T. Chishti, and standing counsel, secondary education.
1, 2, 3,
For respondents, 1, 2, 3, and 4.
Lordship.
Mr. D. Jagabati, and counsel. Appears for respondent number 5, and Mr. U.K. Nair, and the senior counsel. Assisted by Mr.
S. Hazarika.
S. Hazarika, appears for respondent number 6. Stop. Where's the advertisement?
My lord, page, advertisement is page 19, my lord. Are we not right? 19.
Pursuant to an advertisement.
Page 90.
19.
Dated 35.
35, 2019, my lord.
19,
Selection was held
which
on.
was published in the Dainik Assam
The loss.
for the post of
Principal.
Principal of
Bamun
Bamundongra Higher Secondary School of Barbida District. The petitioner and the present respondent number 6 applied for the said post. Stop. After the selection process, comma, the no.
Records are forwarded to the director for approval.
After the selection process, comma, the it is a state selection board.
My lord, it's by the school selection board.
But the
Then it's
school-
selection board.
the
It was held
schools-
on 15/6/2019, my lord.
School selection board held its meeting on
15/6/19.
15/6/2019.
And therein, my lord, respondent number 6 at 1
Where the respondent number 6
at serial number 1 and the petitioner at serial number 2.
appeared at serial number 1 and the petitioner appeared at serial number 2. Stop.
Then it went before the, my lord, state selection board. And my friend's client instituted 7980/2019 before. this.
Thereafter, it was placed before the state selection board.
Lordship.
Where the state selection board is
My
not
lord would have,
not enclosed.
no, that state selection boards is not enclosed, but the order of his appointment is there, my lord.
My lord will have a look to the my lord, page 23. The facts have been, my lord, already there. My lord, there's no question of state selection board, my lord.
Okay.
I have approached this court apprehending, my lord, his appointment, my lord.
Page 23 order, my lord. And that was direction was to take the matter to its logical conclusion
Oh.
by
In
considering.
the meantime, petitioner approached this court by way of WBC 7980/2019. Apprehending that the respondent number 6 would be appointed to the post of principal of Bamban Dokra Higher Secondary School.
Lordship.
Barbary. Said with petition was disposed of by order dated 16/12/2019,
Lordship.
directing the respondent authorities to do the needful to complete the process of selection for appointment to the post of principal of the said school as per rules,
And also by
and
taking.
also by taking into consideration the letter dated 22/8/2019.
Well, this letter was issued pursuant to my representation, my lord, raising my grievance against his selection program. That, my lord, in the first,
Which was issued
page 23, my lord.
by the
Joint Director.
Joint Director of Secondary
Education.
Education Department pursuant to the representation made by the petitioner
Lordship.
For examining the claim of the petition.
as expeditiously as possible within a period of 2 months.
Then he was appointed. Petitioner was appointed.
By order dated
29/7/2020.
29/7/2021. Petitioner was appointed as the
Principal
principal
of
of
Bamban Dokra.
the said Bamban Dongra Higher Secondary School,
Lordship.
District Laputa.
Then I challenged.
By order dated, have I mentioned? that I mentioned the order dated issued by the Director, Secondary Education Assam.
Then I challenged that, my lord, in WPC 3558.
Para. Being aggrieved. The respondent number 6 instituted WBC number 3558 of 2021 before this court, challenging the appointment of the petitioner as principal of the said school by the order dated 7/8/2021. Para. After hearing parties, WBC number 3558 of 2021 was disposed of by order dated 11/8/2021.
Lordship.
And the operative portion reads as under. Page 31, para 14 and 15. 8-way. Stop. Para. Consequent thereto, comma, the director. Where is that order?
My lord, page 24 of the IA, my lord.
Initially, my lord, page 33 of the petition.
No.
Initially, the secondary education, my lord, Director of Secondary.
No. There is a further development. My lord, page 24 of the IA, 9/3/23, the speaking order was passed.
Thereafter. The
After hearing the parties, my lord, this order 9/3/23 was passed.
director.
No, this is by the, my lord,
The
secretary.
The
Secretary.
Government of Assam. Department of School Education
Mhm.
issued order dated 9th March 2023. By which the respondent number 6. By which it was held that the respondent number 6 may be notified as principal of Bamban Dongra Higher Secondary School now. Stop.
As my B.Ed degree was authenticated. my lord.
As the B.Ed degree of the respondent number 6 was
Authenticated by NCT.
was authenticated by
the NCT.
NCT.
Lordship.
Stop. The operative portion also reads as under.
Then my lord is holding that page 26.
24. We do. Stop.
My lord, the next page 26 is the consequential order, my lord, by the director.
Consequently, the director, the in-charge director, Secondary Education Assam, passed the order dated 29/4/2023, reverting back the petitioner to his original post of postgraduate teacher within bracket advanced Assamese of Rihabari Higher Secondary School District Parbita, and
Appointing me.
appointing the respond number 6 as principal
Of
on
the set.
regular basis of Baman Dongra Higher Secondary School.
All of them. One, my lord. Can come back, oh, my lord.
Okay, we can come back at
Gotcha,
2.
gotcha.
We'll come back. What was directed by the order dated?
Well, 11/8/2021.
Order dated
11/8.
11/8/2021. Was that the concerned authority shall call for the reports from the Papita BT College as well as from the NCT. Thereafter, after arriving to effectual satisfaction, appropriate orders would be passed. The order for the director that it was only when the concerned authority is to issue an order in favor of the petitioner during oblique respond number 6 in the present petition that the hearing would be held with regard to the writ petitioner and the respondent in the present respondent 6. Now, this has not been done. Accordingly, the matter is remanded back to the Secretary, School Education Department to rehear the petitioner as well as the respond number 6 on the order that is to be passed by the concerned authority. And thereafter, pass appropriate orders in accordance with law. That much will do.
That will do, my lord.
My lord, they'll consider the rival claims of the parties, my lord, because
That is already there, my lord. In terms of para 15, my lord.
While hearing the petitioner and the respond number 6, the rival claims of both the parties shall be considered by the
In terms of para 15, my lord.
in terms of
Para 15.
of the order dated 11/8.
My lord, that appointment of the respondent petitioner was cancelled, but there is a status quo order.
that will continue.
So my lord may say that that would be subject to.
Status quo order passed by this court earlier shall continue till a final decision is made by the concerned body.
Lots of.
With
Lots
the
of.
above directions, the petition will be disposed of.
And my lord, the order,
In view of the order passed today in the main writ petition, I also stand in disposal.
Lots.
and the order may kindly be communicated to us, my lord, by the authority.
That's right.
That you will automatically get, I think.
Education department, my lord, you can't say. My lord, we'll put that. No.
uh, The outcome of the concerned authority shall thereafter communicate the orders, order passed to the petitioner as well as to the respond number 6 for today.
My lord, we'll put a time frame also, my lord. For
Oh,
finishing
okay.
the process. my lord.
Within a period of 2 months from the date of receipt of the copy of the order.
Much obliged.
Obliged.
11 and 12. Motion.
Yes, Chaudhary,
Yes, my lord.
I've already passed, issued notice. Did I? No, issued notice only on the prayer for interim.
Lordship, because they have come against an order which was passed a long time back.
When?
Lordship, let me take instruction. On the interim pair also, Lordship.
No, what this court is suggesting is till the next reasonable date. Post held by the petitioner should not be filled up. That's all.
The post unmarked for petitioner.
Lordship, let it come next week. Lordship, I will have the instruction.
Why next week? We can have it this week.
Lordship, Friday, some difficulty is there in communicating. Lordship, Lordship may take it up next Monday. Lordship, I will have the
Okay, we
instruction.
wait till next Monday.
I just hope that they are fair to the court and not fill it up, Lordship.
But Mr.
M. Goswami. M. Goswami.
M. Goswami, Learned Counsel for the petitioner, on request made by B. Chowdhury, Learned Standing Counsel, BTC.
BTC.
Yes, the matter on 26. Both item 11 and 12. I'm not issuing notice then. On 26, I'll issue the notice.
Yes, ma'am.
Lots of time. For a 26, 21. 1 minute. Sorry. 2016. Total.
27 level for 28.
28. Lordships, I have some, can it be on 28?
Okay.
Permission.
And on the next occasion, Lordships, I may permit it to address your court by the DC. DC, Lordship. 28.
Why VC but in the first place?
Worships, though I am from here, I practice in the Supreme Court.
Your junior can appear.
Okay.
I've heard everything that you have.
Yes,
to
yes,
submit.
Lordship. So, no, because Lordship has now not issued notice. So in case Lordship needs to be addressed on any issue again.
Not referred.
Very good, very good. He can be, because Lordship, if I understand, then Lordship would only consider passing of the interim relief.
Yes.
Because Lordship will see in the other similar matter that relief has.
Let us see what Chowdhury comes with, what instructions comes with.
Yes.
If he gives an undertaking that nothing will happen, I will not pass interim order.
Very
good. If he does not come with instructions,
Lordship,
I'll
I will
pass
have
for
the
interim.
instruction.
interim order in terms of the previous one.
Yes.
I'm so.
26.
Then in that case, 26.
Then let it be on 26.
Okay, 26.
I'm so grateful. So good.
21, admission.
Please, Your Lordship.
Yes.
The relief that is being sought for by the petitioner association is in the process of being redressed by the departmental authorities. That is why Lordship on the last occasion, in fact, an order was passed calling for the relevant files by which the relief was sought to be redressed. Lordship will kindly peruse the orders dated.
You are considering the matter.
Lordship, this can be disposed of, in fact. The records are already here.
Records are here, government has to go through and whether the decision has been taken or not, final decision has been taken or not.
What?
Whether a final decision has been taken. Bora?
My lord, this is from the government, it has come, the file has come from the government, and for the.
The records are relevant files are here. That is what has been, what was submitted.
We have received the record, my lord, otherwise.
Whether a final decision has been taken.
From the record, it is seen that.
But all records are here. How can they take
Yes,
a
my
final
lord.
decision?
Lordship,
Here,
may I
it
just
has been
submit?
mentioned that matter may be placed before the cabinet, my lord.
Oh.
After detailed deliberations, cabinet directed that proposal for resignation of the post of diet, CTE and IASE be re-examined in consultation with stakeholders. After thorough examination on the issue, the department may bring an appropriate cabinet memorandum to the cabinet.
It had to be written.
Lordship, may I submit? Lordship will kindly peruse the impugn order at page 79. I'll make my submission how it can be, because he has already made his submission in what stage their process is at present.
Yes.
Lordship will kindly peruse the last part, one paragraph. In fact, this is the second round of litigation. And the pursuant to the Honorable Court's order dated 9/12/2019, this order has been passed. That they are in compliance of the Honorable Court's order dated 9/12/2019, passed by the Honorable Guwahati High Court in WPC number so and so, which was disposed of with a direction that the respondent authorities to consider the representation dated 17/1/2018 as expeditiously as possible, preferably within 4 months and at least before finalizing.
Where are you reading from?
Lordship, the last but one paragraph at page 79, order dated 18th of May 2020.
Yes.
Yes. Has your Lordship got it?
Yes.
Starting from order dated 9/12/2019.
1 minute. Last part. One paragraph.
Lordship, probably if your Lordship first peruses the order dated 9/12/2019, by which the earlier writ petition that was preferred by the present association was disposed of, it will make things clear.
Where's
Close the
the
grip.
order?
At page 76. 9/12/2019, 76.
Yes.
We can skip over page number 76. We can start from page number 77. Last paragraph. It has been submitted that the state government has been representing to the competent authorities about certain steps like creation of common cadre of teacher educators, which is meant for both the SCRT and diet, have already been completed by creating a separate cadre. Thus, it seems that the authorities had proceeded in restructuring, but without making any changes in diet, while restructuring reorganization only in respect of SCRT. It has been submitted that as per the guidelines issued by the MHRD in 2012, the central funding is to be routed directly to the state education secretaries, then to the SCRTs for onward disbursement to Institute of Advanced Studies in Education, College of Teacher Education and Diets, and the state budgets heads are put factor in the state share and the central assistance. It has been submitted that since the central funds are routed through the SCRT, there is a possibility that appropriate funds may not be made available for restructuring and strengthening of the diet in terms of the aforesaid policy framed by the MHRD, but made available only for SCRT. This court is of the view that this is a matter which should require proper application of mind by the authorities, as the guidelines contemplate restructuring of diet also, and not only the SCRT. Accordingly, the authorities will consider the representation so submitted by the petitioner for restructuring and strengthening of diet, so that the benefit which has been already conferred on the SCRT can also be extended to the diet. Accordingly, the present writ petition is disposed of, directing the respondent authorities to considering the representation dated 17/1/2018 submitted by the petitioner as expeditiously as possible, preferably within a period of 4 months and at least before finalizing the restructure of this SCRT, so that restructuring and reorganizing of both the diet and SCRT can be completed at the same time, and both can have similar benefits from the date of receipt of a certified copy of this order along with a copy of this writ petition. Okay, so the basic grievance was that there is a restructuring and reorganization policy of the centrally sponsored scheme. The centrally sponsored scheme for teacher education engulfs within its encompass all the bodies which are operating function, which have been instituted for preparation for improvement of the teacher education all throughout the country. And the diet, that is the District Institute of Education and Training, is the body which is responsible for improving the teacher education at the district level. And this is the association which is before the Honorable Court ventilating the grievance that the restructuring which has been envisaged by the central government, by the Ministry of Human Resource Development, that does not only confers benefit only on the SCRT, that is the State Education Research and Training, but also on the diet bodies and the other bodies. And there is a basic there is one more policy that has been envisioned in the guidelines, is the creation of a common cadre of teacher educators, which will involve all the teacher educator bodies. Now the order, that is impugn order, has been passed pursuant to the Honorable Court's order at page 79, which I had taken your lordship previously to. The last but one paragraph, they say that in compliance of the Honorable Court's order, they are doing all these things. The order dated 9/12/2019 passed by the Honorable Guwahati High Court in WPC number so-and-so, which was disposed of with a direction that the respondent authorities to consider the representation dated 17/1/2018 as expeditiously as possible, preferably within 4 months and at least before finalizing the restructuring of SCRT, so that restructuring and reorganizing of both the diet and SCRT can be completed at the same time and both can have similar benefit. Therefore, the government of Assam in the elementary education department has already processed 3 files. These are the 3 files which they have already processed. File number so-and-so since June 2014. Matter relating to common cadre of SCRT and TEIs. TEIs is the Teacher Education Institutes. Educator Institutes. Number 2 is file number so-and-so since January 2019. Matter relating to upgradation of post. And number 3 since January 2019, matter relating to redesignation of post. Now, Lordship, what we want is that, as it is, they have said in compliance of the Honorable Court's order, they are already processing these 3 files. We want finalization of the process which they have initiated by these files. And as it submission made by the Learned Council for the Education Department shows that now they are on the stage of the cabinet memorandum. The cabinet memorandum has to be prepared and that will be passed by the cabinet. So Lordship will direct them that since these 3 files are already in process since the year 2014, and these they are bound to take it to its logical conclusion, because first of all, the guidelines on the basis of which the restructuring of SCRT has been carried out, that itself says that there must be a common cadre of teacher educators. Otherwise, the restructuring process has been funded by the central government in the ratio of 90:10, state central is to 10. That fund would not be released. So they are bound to complete the restructuring of the Diet Association also. These files has to be taken to its logical conclusion. That is the only direction we are seeking at this point of time. So far, what they have done with the STRT, that they have done, we are not on that now. Whatever benefits that has been granted to the SCRT, that should be granted to us. And that can only be granted when these 3 files are finalized. These 3 processes are concerned. Lordship will fix a time period within which they will finalize this process. Because since 2014, it's almost 10 years. They are manipulating with the central government's policy also. In fact, they had submitted before the central government that there is already a common cadre of teacher educator for the state of Assam that we have placed here, that I can show. So they have to, Lordship, I'll just place that particular paragraph at page 66. Page 66. There's already a representation before the MHRD.
Page?
Page 66.
Yes.
Page 66, the last paragraph 3.8. Separate cadre of teacher educators. There is a need of separate cadre of academic, educational, administration, and technical faculty at SCRTs and diets, without which there is a gap related to education and training. Creation of separate cadre for teacher educators is also one of the trust areas under CSST, that is the centrally sponsored scheme for teacher education. However, this line is important. 16 states have submitted in the TEAB, Teacher Education Advisory Board, that they have separate cadre for teacher educators. And the second state here includes, after Andhra Pradesh, is Assam. That is, Assam is already represented before the Teacher Education Advisory Board, that is the MHRD. For that, we already have a common cadre. Whereas that process, as revealed from the impugn order, that process has been, they have started in the year 2014, it's still going on. They have still not finalized. They have, in a way, they've manipulated before the MHRD and have even manipulated with the guidelines and the scheme that has been formulated by the central government. And as regards, Lordship, the statement submission I made that the funds are, the entire restructuring funding has been done by the central government in a ratio of 90:10. And unless and until that common cadre teacher educator for common cadre for teacher educator is created, even that funds probably will stop, because that was subject to the creation of a. If your Lordship kindly takes up the affidavit in reply which we have filed, we have enclosed that document there.
You have
There is-
in reply.
Yes, there is an affidavit in reply which were filed on 21/12/2020.
In which case? Okay.
Lordship, there is one case only.
Okay.
We have filed a reply against the affidavit in opposition filed by the respondent number 2.
Yes.
If your lordship takes up page 27. This is
Yes.
an extract from the same guidelines which they are relying on. Page 27, serial number 5. Salaries of faculty, has the lordship got it?
Yes.
Salaries of faculty and staff of SCRTs in respect of additional post sanctioned and filled up after the introduction of the revised scheme in accordance with the suggested organizational structure for SCRT after the state government notifies the revised organizational structure, staffing pattern and strength. These would be subject to the condition that the state governments create a separate cadre of teacher educators. Everything is subject to that. That was one of the basic central policies in the entire restructuring process, which they have failed to finalize till date. We only want finalization of that policy which they have processed, which they have initiated in accordance with the MHRD's scheme in the year 2014.
Yes,
Not-
Katanya?
Yes, my lord. We have already prepared a cabinet memorandum, my lord. I have marked this one.
Lordship will direct them to finalize these 3 files within a period of say 3-4 months. Probably. Because they are not saying that we are not entitled to the benefit. They are saying in compliance of that
There's
policy
one
and
two
on the
flags, my
report
lord,
card.
pink color flags, my lord. This is the cabinet memorandum.
This has not been submitted yet?
No, my lord. This is of 2021, my lord. And the impugn order is at page 79 is in the year 2020.
What's taking you so long?
My lord, pursuant to this case is pending, my lord. Since 2020, my lord.
There is no stay order of the impugn order also. There is no stay of the impugn order.
But the record is with us, my lord.
Record was called for with probably last month.
No, my
And
lord.
that was
Record was called for, my lord.
2 months
Long
back
back, my lord.
probably. 2 months back probably.
28/7/2022. Record was called for.
But that cannot be a ground, lordship, because this.
Do you want this case to be disposed in the manner you are submitting now?
Yes, lordship, finalization of only this.
Or do you want the cabinet to take a decision and await the decision?
Lordship, these 3 files, they have already.
These records, we can return it back, directing the cabinet to take a decision.
Yes, my lord.
Direction to cabinet to take.
This court can't give a direction,
Yes,
but
that,
directing the respondents to place the cabinet memorandum before the cabinet.
yes, or lordship, as it is, they have already initiated the process, these process for creation of common cadre, upgradation, etc. Since the year 2014, let them finalize their that process within a fixed period. Lordship will not be called upon to direct the cabinet or only that. The whole process.
But then the issue is this,
Yes,
unless the cabinet takes a decision, nothing is going to materialize.
I understand, lordship, if your lordship directs them to finalize the process, that will take upon its, within that will include the cabinet decision also. Because unless and until, yes, cabinet will have to take a call. If your lordship directs them to complete the process, that will include the cabinet decision also.
Yes, Katanya, what do you say?
Yes, my lord. My lord may direct to finalize the process, my lord, for upgradation. As it reflected in the cabinet memorandum also, my lord. We have taken the views of all the departments. After taking the views of the department, my lord, we have restructuring it, my lord.
Yes, after taking the view. So everything is in the positive thing.
Then I'll dispose it.
Yes, Lordship, they'll finalize these three
Heard
process.
MS D. Borg, go ahead, learned counsel for the petition. Also heard. You are appealing for
I am appealing for respondent number 3. My friend,
1 minute.
opinion is appealing for respondent number 2.
Two, my lord.
Who are these private respondents?
She's appealing.
Lordship, these private respondents are the officers of the SCRT who had been conferred the benefit of the restructuring process. At that point of time, we had a grievance had against them, but right now we do not have any grievance.
Who appears for the union?
I'm appearing for respondent number 7 to 33.
No, no, Union of India.
I can look at.
Mr. NG Das.
DJ Das, Your
Das, DJ Das. Then CGC
Lordship, CC.
appears on behalf of respondent number 1, comma, Mr.
I'm appealing. NJ Khatani, my lord.
NJ Khatanya, Leonard Standing Council Elementary,
Elementary.
appears for respondent 2,
2. I'm
Two
appealing.
only.
2 only.
2,
No, I'm appealing for respondent number 3.
as Borough Leonard Standing Council,
SCRT, respondent number
SCRT, appears for respondent number 3,
3.
MS
P. Sharma.
T. Sharma, Leonard Standing Council, APSC, appears for respondent number 4. Finance,
My lord, H. Julius may be reflected. I will inform you. Okay.
you appearing?
Yes, OHLA, Your Lordship.
Mr. H. Elia, Leonard Standing Council, Finance, appears for respondent number 5. The Personnel Department,
Government will appear. Government is there. Sakya, Mr.
Mr. P. Cycle and Government Advocate appears for respondent number 6, and MS
And Mahanta,
and Mahandal and Council appears for respondent
7 to 33.
7 to 33. Stop. Para. The petitioners before this court are aggrieved by the inaction of the state respondents in restructuring the District Institute of Education and Training within bracket DIED in Assam, despite necessary restructuring being done in respect of the State Council of Educational Research and Training within bracket SCRT, in terms of the recommendation made by the Ministry of Human Resource Development within bracket MHRD for restructuring and strengthening the SCRT as well as the diet in the state, in terms of the report made in 2009 as well as the guidelines for implementing such recommendation issued in 2018. Stop. Prior to the institution of this writ petition, the petitioners had also approached this court by filing WBC 9056 of 2019, which was disposed of by order dated 9/12/2019, directing the respondents to consider the representation dated 17/1/2018, submitted by the petitioners as expeditiously as possible, preferably within a period of 4 months, and at least before finalizing the restructuring of the SCRT, comma, so that restructuring and organizing of both the diet and SCRT can be completed at the same time, and both can have similar benefits from the date of receipt of the copy of the order. Stop. Draft, comma, the Commissioner and Secretary to the Government of Assam, New Paraha, Elementary Education Department, passed the speaking order dated 18th May 2020. And where's the operative portion?
Lordship, the last but one paragraph, the order dated 9/12/2019 at page 79.
No. The operative portion of this order?
Order, speaking order, Lordship.
Yes.
Operative portion, Lordship, the last paragraph at page 80.
And the operative portion, it says on the page 80. 8A.
Last restructuring and reorganization of
Yeah.
Directorate of SCRT Assam and 83 post sanction for
Being aggrieved with the speaking order dated 18th May 2020. Petitioners are before this court with before this court by way of the present. For a perusal of the speaking order dated 8 May 2020 would indicate that 3 files have been processed for considering the case of the petitioners, i.e. reorganizing and restructuring of diet in Assam. The 3 files were processed as early as June 2014, January 2019, and January 2019, respectively. Stop. A further perusal of the order indicates that the respondents are initiating a process, but at a very slow pace, without taking into account that the restructuring which has been initiated in terms of the guidelines of the MHRD relates back as early as 2012. Correct. Stop. At this stage, Nipara. Mr. N.G. Katanian, London Standing Council, Elementary Education, submits that the cabinet memorandum has been prepared and is awaiting is prepared. However, the same is yet to be placed before the cabinet, inasmuch as the memorandum, the file containing the said office cabinet memorandum is before this court. Stop. Para. After hearing parties, this court is of the considered opinion that it would be in the hands of justice to dispose of this petition instead of keeping pending by directing the respondents to expedite the restructuring and reorganizing the diet in Assam. Along with the SCRT has been done.
Yes, that has been done. SCRT is completed by their own admission.
So that is in violation of this court's order.
Yes, violation also is court.
What did I say?
If I may just point out here at this stage that the court's honorable court's order was also put to challenge by the private respondents before the division bench. They had to withdraw that decision order. Writ appeal.
Organizing the diet in Assam. The diet in Assam. In as much as cabinet memorandum has already been prepared for that has already been prepared. Stop. concerning that the processing of files has taken place as early as in the year, as early as June 2014, this court directs the respondents to expedite the process and bring the same to its logical conclusion within a period of
2 months, my lord.
2 months. Can you do it? When is the cabinet going to sit? Does it sit daily?
Lordship, it has come from him 2 months, let it be.
No. Let us be practical. Within a period of 4 months from the date of receipt of a copy of the order of this court. That much will do, I think. Nothing much we can say.
Yes, Lordship had just observed that this is also in violation of the earlier court's order. That observation may be recorded because this is also.
Before parting with this, with the records, this court is constrained to observe that no, let us not take that step. Let them continue.
Lordship, why I was making that submission, because they themselves in the impugn order, the commissioner says that in compliance of that honorable court's order, they have processed these 3 files. That is why, Lordship. This will add strength.
No. It may worsen your case. You send back the files immediately?
Yes, my lord.
Lordship.
Obliged.
In view of the order passing the amendment. Yes.
25.
Yes, Naya.
I appear for the university, my lord. Respondents 2, 3, 5, and 6,
My lord, the matter, my lord, pertains to the appointment of my lord, Director of Students Welfare, my lord, in Cotton University.
I'm sorry, my lord.
My lord, will kindly see is very narrow campus the matter is this, my lord. Only 4 dates. There was an advertisement for the post. That post your lordship will kindly see at page 76.
Yes.
76, you kindly see the number. The post is serial number 202 on the top left hand side. Director of Students Welfare. Lordship found it. Number of post is 1. Lordship got it. Page 76.
What date is this advertised?
76 is 7/3/2000. It starts from 75. 75. 7/3/2020.
Yes.
Lordship got it. 7/3/2020. This is the advertisement for non-teaching post. Now, like, kindly turn to page 76. Is serial number 2. First post we are not concerned. Second, we are concerned of Director of Students Welfare. Number of post is 1 for a term 5 years. Now the essential qualification, your lordship got it. Now Roman 1, kindly note this qualification is important. Roman 1, at least 15 years of experience assistant professor in academic level 2 and above, or with 8 years of service in the academic level 12 and above, including associate professor along with experience education administration or so and so, so and so. These are the, my lord, the essential qualification criteria that has been fixed. Now, my lord, on the basis of that, my qualification I annexed at page 80. Page 80. This your lordship kindly note down. This is my qualification. Page 80 and 81. 80 and 81. This is my qualification. Now this continues to 82. Now 83 also other qualification. Your lordship will kindly note down. There is also in the column of the post, that is page 76. what are the criteria? Other criteria is this administrative experience at page 83. Lordship got it?
Yes.
Page 83. This is my also the experience which I have. Administrative experience, it goes from 83, 84, 85, 85. Now, on the basis of that, my lord, I appeared. But at page 88, I was not selected. At page 88, there's a notice. Selected candidate for the post for controller. Second, selected candidate for the post of director of students welfare in Cotton University, Dr. Prasanta Sharma. So I was agreed by that, and I am before this honorable court. This is the case. Now, I'll straight away, I'll not trouble much, and it's a very narrow campus affidavit of the government, Cotton University. Where is my affidavit? Like, give me all five. Good. Now, kindly see the affidavit of the Cotton University. That is most important because they are the authority who decides it.
Respondent 2 and 3.
Respond number 2 and 3. Correct, my lord. 2 and 3. If your lordships find the comparative statement, the marks at page 104. 104 kindly be seen. 104 at 105. Serial number 5. At 105, serial number 5, that's a petitioner. Now, my lord will see what is the percentage of mark, date of birth that your lordship will not count. Age on percentage of mark in PG, minimum 55 mark percent. Lordship got it? Kindly see my column 62.12. And if your lordship compares, next page at page 106. At serial number 9 is the respondent which they have selected. Kindly see, my lord, the percentage of mark 55.75. So see the difference. One, I am showing it. Now kindly see the next column. Kindly see teaching at page 105. At page 105, next column, that is after this percentage of mark, teaching experience assistant professor, academic level, C level 11, above not less than 15 years. Your lordship recollect, if your lordship kindly see 76, that is qualification criteria, I have shown that. So kindly see what is my experience, teaching experience in page 105, after 62.12, 23/11/1999 to 04/04/2020, 20 years, 4 months experience. Lordship got it? Now kindly turn to page 106. See the respond number 4 experience. 17 years, 3 months. Apparently, I am more experienced than the private respondent. Marks also, I have got better marks. Now, if your lordship now experience nil, that next 105 of respondent serial number 5, petitioner, kindly see other qualification experience column. PhD, MPhil, B.Ed, head of department 4 years. Now see the next at page 106, serial number 9, that's a private respondent. PhD, program officer, NSS. So this way, my lord, my academic was much more higher than the private respondent, but I was not selected. And what is the stand they have taken? Kindly see page 95. Very short, my case, my lord. Page 95. They have to justify, my lord. 95 para 9. That in regard to the statement made in para 8 of the writ petition, deponent begs to state, out of the 15 candidates who had applied for the post of Director of Students' Welfare, 5 candidates were shortlisted and all of them have the requisite qualification and experience as required in the advertisement dated 7/3/2020. All the said 5 candidates, including the writ petition respondent 4, appeared in the interview before the selection committee. Selection committee assessed the candidate and its wisdom, recommended the respondent for selection to the post of so and so. So they said in his wisdom. What is the wisdom, my lord? What is the assessment you made it? The assessment is on the basis of those criteria. So apparently I have demonstrated what is the criteria I acquired, what is the criteria of the private respondent. You cannot do it on his wisdom. There is some marking system, how you have done it. So in the meantime, what we have done earlier, and I was fine. And said that how this selection, you had a committee, selection committee, how they have selected, on what basis, court allowed. And I think my learned friend is appearing for the selection committee itself, the Cotton University. So this is, my lord, my case. It's very narrow campus. How this is my mark, which I obtained. This is a private respondent. You have to justify it. And this page 95 is their wisdom, in his wisdom. And my writ petition, paragraph 12, kindly see, my lord. Kindly see paragraph 12. That the petitioner came to know from reliable source that the respondent for is less qualified and less experienced than the petitioner to hold the post of Director of Students Welfare in Cotton University. Despite of that, the respondent was selected mala fide, ignoring the qualification experience of the petitioner. Respondent authority dehoring all the rule and procedure prescribed for the aforesaid selection mala fide and non-transparently selecting the respondent for the aforesaid post. So my apprehension at that time was correct. At that time, Cotton University has not filed any affidavit. Subsequently, affidavit was filed. And that what statement I made in paragraph 12, it appears to be correct. So in spite of the lesser marks, they were selected. Now, one paragraph, kindly see, para 8, my lord, I have mentioned. Para 8 is a long one. What experience I have done, what experience I have got, that I have narrated in para 8. That's only. I'll not trouble you lordship by reading the entire. Para 8 is my experience. What other experience also the petition I had. Now para 13 kindly be seen. One para I'll trouble, my lord. Para 13. Petitioner begs to state that while going through the said selection list, candidate respondent for name was shortlisted at 4th position. Shortlist to notice dated 18/8/2020 published by Respondent 3 and observing the petition name was positioned as serial number 1 as the petitioner is more qualified and experienced candidate in respect of the welfare students. But astonishingly, in the final declaration of result, Respondent 4 has been selected and appointed in a very illegal manner by depriving the petitioner. Came to know from reliable source the shortlisted candidate list prepared in order of their better position in the interview. When I moved this petition, my lord, there was a prayer which was made in the writ petition. I have challenged the appointment of the private respondent at page 88, which I have shown. And at page 18, this is a prayer which I have sought for in the writ petition. Para 18, page 18. In the aforesaid premises, humbly pray in respect to advertisement published for the post of so and so and issue a rule so and so should not be issued for setting aside question the impugned select list dated 9/10/2020 issued by register so and so as to why, my lord, all this and impugned select list dated so and appointment order and other constitutional order arising out of this said appointment or why direction should not be issued so and so. Now an interim order which was passed by this honorable court, kindly see that at the order which was passed by this court while it was moved on 29/1/2021. Kindly see the order, man, which was passed. Lordship got it? The order of this court 29/1/2021 below. The appointment of private respondent to the post of Director Students Welfare in terms of notice pursuant to the advertisement shall be subject to the outcome of the recognition.
That means respondent number 4 is continued.
I'm sorry.
He has been appointed.
He has been appointed. That will be now decision of this court, will be subject to further orders of this court. I have challenged his appointment order. Now, your lordship depends on
This
the
is for a
result.
period of 5 years.
This is no period of 5 years. 5 years. Now, today we are 2021. 23 now.
I think the advertisement was issued on
Advertisement
2020.
7/3/2021. 22, yes. 22. 22, sorry. 22, no? 20. 7/3/2020. So whichever is, is a short point, my lord. They have to justify because he said in his wisdom. What do you mean by wisdom? Because it has to be decided on some assessment has to be made by them. It is an assessment, my lord. I have seen the comparative chart which is given by them itself. Interview, oral interview, I don't know. Oral interview cannot be the only criteria. Nowadays, oral interview has been, most of the exam your lordship has seen, there is no oral interview, like a all written test. Nowadays, what I have seen, number of cases was moved. Oral interview is basically taken away, is by written test.
Did you have an interview also?
Interview, yes, interview. Oral interview was there. That I don't know what is there, they will know better.
Yes, right.
18/9/2020 was the oral interview. 18/9/2020 online. It was online.
Was held online, my lord.
It was COVID. That time it was COVID, so it was an online interview. 18/9/2020. That's a small point, my lord.
My lord, if my lord comes to page 76 of the petition, the qualifications relied on by my learned senior, my lord.
Yes.
My lord, these are essential qualifications. A postgraduate degree from a recognized university with at least 55% marks or so and so. 2, at least 15 years experience as assistant professor in academic level so and so, and or with 8 years service in academic level 12 so and so. 3, comparable experience in research establishment or other institutions of higher education. 15 years administrative experience, of which 8 years shall be as deputy registrar or an equivalent. Desirable experience in students' welfare, sports activities, etc. Should have good interpersonal skills to interface with students, teachers, staff, public, and media at all levels. A PhD degree is desirable but not essential. My lord, what is this post? This post is that of Director of Students' Welfare. It is not a teaching post. My lord, the qualifications which my learned senior relied on are essential eligibility criteria. A person who meets those criteria, they are shortlisted, they are called for the interview, and the selection committee selects. My lord, having higher marks in one particular examination will not entitle them for selection. Suppose I get the first position in metric in HSLC. I get the first position in higher secondary, in graduation, post-graduation. Can I be selected? If it is only on the basis of marks, yes. But here it is only the eligibility criteria. Both the respondent as well as the petitioner, they meet the eligibility. They were assessed by the selection committee. One of the selection committee found the private respondent to be more suitable to the needs of the university, and he was selected. The scrutiny sheet which I had annexed, my lord, which my learned senior has relied on, that is a scrutiny sheet. That is not, my lord, that of the marks in the interview. Here, on scrutinizing the applications, we find out who are experienced, who are qualified or not qualified. If my lord looks at the remarks column, we have rejected many candidates. There were a total of 15 candidates. We have rejected many. If serial number 1, not qualified, no experience. 2, not qualified, less experience. 3, qualified to produce notification of promotion, so and so forth. My lord, here my learned senior has left out a certain paragraph in the writ petition. If my lord comes to paragraph 22 of the writ petition, my lord, the entire claim of the writ petitioner while moving the writ petition emanates from para 22, page 15 of the writ petition. My lord. Of course, my learned senior has not argued on that. That the petitioner begs to state that in spite of selecting at first position in the shortlist and having all the requisite qualifications and norms as set forth in the advertisement, and that too much more than the private respondent number 4, the Cotton University having not selected her, and as such action of the Cotton University is highly discriminatory, so and so. My lord, she feels that since she was at the first position in the shortlist, she needs to be selected. And since she was not selected, this is discriminatory on part of the university. On the shortlist, we do not allocate marks. In shortlist, we only put in those who are shortlisted for the interview. That is not on the basis of marks in the selection process. So that will not give any rise. Then para 8 of the writ petition. She had made many omnibus statements. Para 8 of the writ petition, my lord. Oh, sorry. Yes, para 8 at page 9. Starts at the bottom of page 9.
Yes.
The petitioner begs to state that the petitioner appeared in the interview conducted online mode by Cotton University. In the said interview, the petitioner did very well. Besides that, the petitioner having all the requisite qualification to lead as director of students welfare, but despite having all the qualification, petitioner is deprived from appointment to hold the aforesaid post. The petitioner begs to state that the private respondent is much junior to the petitioner and having less qualification as well as less experience in extracurricular activities than the petitioner. Private respondent has been selected only due to his extraneous consideration. The petitioner came to know from reliable sources that one of his relatives was in the selection board, and for that reason, the private respondent has been selected. These are the two grounds which were made out in the writ petition, but without any substantiation thereof. My lord, in my affidavit, I had stated that she had not made any of the members of the selection committee with whom she had alleged malafide to be members. They had moved an IA, my lord. In the IA, the selection committee, as well as, my lord, IA number 1623. I filed my objection as well there, my lord. In IA number 1623, she had, my lord, applied for, my lord, impleading the vice chancellor and other members as well as the selection committee. This court did not allow it to be done, my lord. Only, my lord, the selection committee as well as the executive council, because the executive council approves the appointment. Only these two were allowed because there is no allegation of malafide, particularly against any person. My lord knows very well, my lord, that an omnibus statement will not do. She had to substantiate it. These were the grounds she had averred in the writ petition, no substantiation thereof. And my lord knows very well, my lord, that in academic matters, selection is to be done by the, my lord, selection committee. This honorable court, in my humble submission, cannot sit in appeal over the decision of the selection committee. In my humble submission, I have certain decisions which I would like to place, my lord.
Only on the grounds, you're over, only. Because one thing I just want to say, my learned friend in the midst of argument, that there was a direction passed by this court to produce the record, to see in what manner, in his wisdom, what they have done it. This is the only, your lordship feels that I cannot overread the assessment. I cannot overread the assessment which has been done. Of course, we also know, we are aware to what extent the judicial review. Your lordship will not sit over the decision. They said in his wisdom. What wisdom? Record will speak.
I can produce the record.
Yes, that's only what I am saying.
At the moment, no, my lord, but I can produce it, my lord.
Only what
tomorrow I can produce it, my lord.
Your lordship sees the record. Lordship finds that there is no question of any interfering with this, with the assessment which they have made. Only what I was, when I have seen the affidavit, I have seen one in his wisdom. Yes. What wisdom? That's only is troubling us. What is the wisdom?
My lord, naturally.
Assessment.
After this scrutiny, what is the next step?
My lord, it will place its recommendation. The recommendation will be accepted by the executive
now, how
council.
do you recommend from this?
Not from this, my lord. From this, the interview is conducted. After this, this is only for the scrutiny. This is a clerical exercise. After this interview is conducted, the interview board members, they recommend. That recommendation, my lord, is accepted by the executive council. And my lord, the interview committee, selection committee, has to select persons in its wisdom. Naturally, my lord. If there is no wisdom in selection, how can it be a wise selection of a person?
Produce the records.
I can produce, my lord.
That's all. But Mr. D does.
Tomorrow, my lord.
Senior counsel. Assisted by Mr.
M. Sarkar.
M. Sarkar. Counsel for the petitioner. Mr. P.T. Nair, Lennox. You're the standing counsel,
Standing counsel.
Cotton College.
Cotton University.
Cotton University.
2356. Like.
Appearing for respondents, 2, 3, 5, and 6. Shall produce the records.
Or Thursday, my lord. This Thursday.
It's no problem. Monday.
My lord, Monday, Tuesday, Wednesday.
No, Sunday.
Monday and Tuesday, I won't be. I'm some difficulty.
Whichever tomorrow, day after tomorrow.
On
whichever
Thursday,
is-
my lord.
22nd.
It's
It's a
deeply open.
judgment, you just give it to me. You have to give
Sure,
a
sir.
judgment. That's okay.
26.
Deeply open.
Deeply open.
Citation to be-
May I please, Counsel, here issue is that, my lord, my name has been recommended by the District Scrutiny Committee for provincialization as a Assamese teacher, my lord. Thereafter, my lord, director has did not provincialize my name, my lord. Due to the-
Here, I
my-
have to see the
I-
instruction,
My name is does
we are
not
going to
located
file
in
an
the dice
affidavit
code, my
shortly.
lord. And does not located in the dice code, my lord. This issue already been dealt with by this honorable court in, my lord, Kishore Kumar Nath, my lord. Dice is also not necessary, my lord. I am the Venture Junior College teacher, my lord. In the definition also, my lord, in 2017 Act, there is no mentioning about the dice, my lord. Yeah, my lord, the issue is already dealt with, my lord. Therefore, I am paying to dispose of the matter, my lord. As for this, the judgment, my lord.
Yes, Chief.
Yes, we are going to file an affidavit by this week, even by Friday. Let it come on next Wednesday.
Okay, you're Mr.
S. Hazarika, my lord.
S. Hart S. Asanival in the council for petitioner. Mr. S.M.D. Chistil in the standing council.
Secondary education.
Secondary education submits that he'll be filing affidavit within this week stuff. Accordingly, list the matter after 1 week.
Yes.
Any date may be fixed, my lord.
It's difficult now. It's
My lord, I can understand, my lord, if vacation is coming on, my lord, therefore. my lord. As my lord, not only limited issue is that, my lord, only the dice code, my name is not there, my lord. Already, my lord, this court has already decided the issue, my lord. Unless keeping it pending, my lord,
28.
my lord.
Yes.
Much obliged, my lord.
27.
May I please, Lordship. My lord, I was appointed as an LP school teacher on 15/7/2004 at Uttar Gunimari LP School. Thereafter, my lord, when the school had to be provincialized, had the headmaster sent certain particulars of the teachers. But in those teachers' particulars, my name was not sent, but the other it was kept vacant. Kindly see, my lord, page 28. Kindly see, Uttar Gunimari, Venture LP School, so and so, so and so. Abdul Basit, head teacher, 2 vacant. So it was kept vacant. And another wrong person's name was forwarded, who is non-existent. So for this reason, my lord, the authority has issued so-called notice against the headmaster. But in the meanwhile, due to not sending my particulars, my post was not provincialized at that time. Then, my lord, I approached the authority that may be seen page 31. My petition, lordship, first page 31, the DO has clarified, kindly see, page 31, to the director of 31.
Yes.
To the Director Remediation Assam, Kailipara, with reference to the subjects indicated above, I have the honor to inform you that Srimati Anjuara Khatun name was proposed as assistant teacher of Uttar Gunimari LP School having dash code number so for provincialization of service who has been working in the school since 15/7/2004 till date without break. So when this was sent to the director by DO, then my lord, the secretary wrote a letter to director that lordship may kindly see page 32. To the director Elimination Assam regarding provincialization of service of Anjara Khatun as assistant teacher of Uttar Gunimari LP School under DO Dhubri. In inviting a reference to the above, I am directed to state that the Uttar Gunimari LP School under DO Dhubri got provincialized with 2 posts of assistant teacher by showing 1 post vacant by your order number so-and-so dated so-and-so. As per records furnished from your end by letter under reference, it appears that due to oversight, the district level scrutiny committees originally recommended a wrong name in place of Anjara Khatun. Subsequently, the district level scrutiny committee rectified the mistake and recommended the name of Anjara Khatun for provincialization as assistant teacher of Uttar Gunimari LP School. While the proposal for provincialization of services of Anjara Khatun was under process, the Honorable High Court passed the order dated 23/9/16 striking down the Assam Venture Education Institutions Provincialization of Services Act 2011. This was followed by repeal of the Assam Venture Educational Institutions Provincial Services Act 2011 and enactment of the new act, the Assam Education Provision of Services of Teachers and Reorganization of Education Institution Act 2017. So, my lord, it was clarified that my name was not sent due to mistake, but it was not a mistake. Actually, it was cunningly sent by the headmaster. However, every authority is saying that due to bona fide mistake, her name was not included. Now, the government has sent a letter to director that as the 2011 Act has been struck down, so it may not be possible. Now, in this regard, my lord, I draw your lordship kind attention. Kindly say that is not applicable in my case as per the order of this Honorable High Court. Kindly see my lord page 40. It's just from earlier, but operative portion page 40, para 13 onwards. 13 May. Lordship has seen. Page 40, para 13. 13. In the instant case, clearly concluded the hearing above, the petitioner being included within the numbers of specified in the schedule. In the schedule means, well, there are 3 posts, 1 language teacher, 1 social science teacher, and another is English teacher. So, there being no other impediment, his service is to provincialized by operation of law under section 4(1) of the Act 2011. Therefore, the case of the petitioner would also be covered by the provision of paragraph 19 of the decision of division bench of this court dated 2/1/2017 in review petition number so-and-so, and the benefits of provincialization that accrued to him by operation of law shall remain. In view of the above, as the service of the petitioner is still provincialized under section 4(1) of the Act of 2011, the court is of the view that there is no requirement of any further administrative order by the department to provincialize his service, and all that is required is to recognize that his service already stood provincialized under section 4(1) of the Act of 2011 in the facts and circumstances of the present case. So, it was observed that under section 4(1) of the 2011, it is presumed as provincialized. Because at that time, my name was not sent due to mistake or due to cunningness of the headmaster. Even then, fact remains that out of these 3 posts, my lord, only 1 post was filled up, headmaster, who represented as another teacher. Another fact teacher's name was provincialized. That has been not acted upon. Now, my case has been always recommended that my name should have been sent. But only the obstacle has been said that as the 2011 Act has been struck down by the Honorable High Court, so it may not be possible. But our High Court says that under Section 4(1) of the Act of 2011, it should be deemed as provincialized. So our case is very simple and clear. So my prayer is this, my lord, instead of throwing me to different as per 2017 Act, I will have to go to tribunal, shall have to adduce evidence just like a civil case, issues would be framed. So another 3-4 years or may take more than those time. But here, when the Honorable High Court itself has clarified, quoting the division bench judgment, so my lord, as the report is very much clear, so director may be directed to consider my case for provincialization in view of the given facts and circumstances of the case. That is the only prayer.
Yes.
My lord, here on last occasion, petitioner was directed to produce her dice code and GST recommendation on 18/5/2022. So
On?
একটু কন্ট্রাডিক্টর আছে, এখন তুমি তো দিচ্ছে, এখন তুমি দিয়া নাই, আর আমি কাপি ফাইল করি এটা সিমিলার কিছু ইনস্ট্রাকশন দেব।
Yes, Mahmood.
My lord, 2 orders are there, my lord. Already I have read 1 order. It is from page 36, operative person page 40. Another order by our High Court, page 42, my lord.
No, that part is this court has directed you to produce a copy of the dice court.
Dice code, it is already mentioned, my lord, in my case. Produce
18/5/2020 order passed by this court.
dice code. Then lordship dice code. Actually, in this case, my lord, I have been engaged. Even then, my lord, it is my duty to carry out the order. Actually, dice code, my lord. Then matter may be listed day after tomorrow, my lord. I will.
after 1 or 2 weeks, my lord, I will tell everything.
Day after tomorrow, this is a very minor matter. Everything is clear.
And
Everything is clear, man. Because they themselves have admitted that there is a mistake. So a poor lady teacher,
who will file everything?
since 2004,
There is contradictory order, my lord.
আগে ডাইস কোড রেকর্ড করো, লেডিং ফাইল এডিশন দিবি।
Let him file, my lord, because 2017 dice code and DSC recommendation is required to provincialization, my lord.
লেডিং ফাইল এডিশন দিবি।
Lordship, this is one thing, the dice code, that is not the
order is passed,
criteria.
order is already passed
Yes,
by
yes,
this.
I understand that, I understand that. It should be only 1/2006 prior to that. So in that view, I have a good case. Now, so far, honorable court's order, definitely I will let it come day after tomorrow, my lord. I will ask the party to bring, if anything with her.
We'll take it up next week.
Yes.
Yes.
Next.
Mr. Mahmood. MU Mahmood. Learned counsel for the petition is directed to produce the dice code concerning the school, pertaining to the school concerns, which includes the name of the petitioner. List the matter again on 27th.
27. 27/6.
28.
Obliged.
That's it. Here we were asked to file affidavit for the last time, but we could not obtain the instructions. That's it. For last time when we given after vacation, we will file it. The takeover is looking after the record. So we have.
Date may be fixed after vacation. Lord.
Fixing a date is difficult data after the.
Otherwise matter not listed. Lord. I have to
We
again.
can make you mention.
Also, any date also after vacation, I have no objection. Any date, Lord.
Mr.
Air government.
Air Double Standing Council,
Higher edition.
Higher Education,
This may be the last round. Many occasions they took time.
Yes, sir.
place for 3 weeks' time as last chance to file counter affidavit. So there's a lot. List the matter after 3 weeks. Enable then a standing council so and so to file counter as last chance. After 3 weeks.
That's great.
3 weeks. Immediately.
Can it be last third week of July? Lord? Any
I
date,
don't
Lord.
know.
Immediately after vacation.
I'll keep it like this. You mention it.
Oh, Lord.
All right.
29 and 30.
The order impugned is the order passed by the director. District level committee pursuant to the order of the High Court recommended for provincialization. The director by the impugned order has cancelled that matter. But till date, director has not filed the affidavit matter.
Yes, who appears for
21 matter.
As per order, my lord, report is there. On last occasion. The director to produce report, my lord.
Let them file affidavit matter. They are not doing it last matter. Several locations the matter has been listed.
Okay, you file your affidavit. But Mr.
B. Chakraborty.
B. Chakraborty and a counsel for the petition. Mr. Air Double and a standing counsel. Elementary education is directed to file counter affidavit. We didn't appeal it out.
After vacation, my lord.
We didn't appeal it
I
out.
have to send back.
Actually, can I give a date, my lord?
Hello.
I can't give it.
Last occasion, this honorable court has directed us to produce a as
So
per order.
you have the request.
We will send back to my.
Next matter after 2 weeks.
Lordship, I am for NCEs, Lordship.
Mr.
RM Das.
RM Das, then it's standing counsel NCs. Appears for the NCs.
Lordship. Deep down.
32 and 33.
Lordship, I am appearing on behalf of counsel of the petitioner, item number 32, Lordship.
Yes.
His father-in-law is in hospitalized, Lordship. The matter may be possible for the day.
I Hassan.
I'm 33.
On request made on behalf of I Hassan, legal counsel for the petitioner in WBC 375 of 2022. List the matter after 2 weeks.
After? Obligation.
May I be the Lordship?
34.
My item is 33.
That is clubbed up with 32.
My lord, in this case, my lord, we have filed our affidavit, my lord, in opposition on 27th of March 23, my lord.
Yes. Yes.
Lordship, I have filed RTI application, Lordship, and received the answer script, Lordship, but upon perusing the answer script, Lordship, I have not got satisfactory mark, Lordship. As I grip the same, I have filed presently petition.
Proceed.
Yes, Lordship, Annex I have, Lordship, page number 76, Lordship, that is the question paper, sociology, Lordship.
Annexure?
76, Lordship, page number 76. That is the question paper of sociology, Lordship. Lordship, against the question number 1 marks 1 lordship. There are 12 question number lordship. Each of the question number awarded 1 marks lordship. Accordingly, lordship, I have correctly answered 11 number of question lordship, but same is lordship page number 85 lordship. That is page number 11 portion 84 lordship. But again, the question number 1 lordship, I was awarded only 10 marks lordship. But lordship, I have correctly answered 11 number of question lordship. Only the 1C lordship
1
that is
minute.
mistakenly done lordship.
Page 85 is your answer, isn't it?
Yes, lordship. I have correctly answered except the question number 1C lordship. That is mistake was done lordship in question number 1C lordship. But I was awarded only 10 marks lordship. As I grip the same lordship, I have filed revolution lordship, but not finding the appropriate the same lordship. And all are correctly awarded 1 marks lordship each of the question, but in top of the page lordship, I was awarded only 10 marks. And thereafter lordship, another 1 lordship, that is a political science lordship, that is Annexa C lordship, Annexa E question paper lordship, page number 24 and 27. 24 and 27 political science lordship. Against the question number 13 lordship, page number 27 lordship. That is question number 13 has mentioned, discuss the consequence of this integration of the Soviet Union, awarded 6 marks to lordship. And another question number 14 lordship, that is awarded also 6 marks, that is examine the political and diplomatic influence of European Union lordship. But lordship, I have correctly done my answer lordship. That is lordship page number 50 and 51 lordship. That is the question answer lordship relating to question number 13 and 14. Page
Yes.
number lordship, page number 50 lordship. I have correctly answered lordship. That is which answer number 13. The Soviet Union distinguished in 1991 in
That you don't need to read.
page number 50 lordship.
Yes.
The Soviet Union distinguished in 1991 and it led to numerous changes and consequences in the world politics. The result of Soviet Union distinguished are number 1, cease of Cold War conflict and
Not required to read it. There's no need to read it.
yes. I have done said answer lordship on
No, what is your grievance?
so lordship, but I was awarded only 3 marks lordship. Even though lordship, I have correctly answered lordship. I was awarded only 3 marks against the 6 marks lordship. So lordship, the I have, despite of the same, I have 5 revolution lordship, but not awarded the proper marks. As I agree the same, I am before your lordship lordship for getting the appropriate marks. That is my only humble prayer.
Who evaluated your mark sheet?
So lordship, direction may be given to the appropriate authority lordship. That is the
Whoever,
higher education lordship for
Who-
examiner.
who corrected your answer script?
Lordship, the examiner says, because lordship, I have filed RTA.
Examiner is an
File revolution.
examiner is an expert, isn't it?
But lordship, I have done requisite fix lordship before the authority.
Can I have
Despite
a,
of the
can I
same
have,
lordship, I was not awarded the appropriate marks lordship.
how do this court know that you have not been given the appropriate marks?
Therefore, Lordship, direction may be given to the higher education Lordship to appoint the examiners to Lordship and properly verify evolution and awarded the appropriate marks to me, Lord. That is my humble prayer. And because Lordship, today's student is the tomorrow future, Lordship. Therefore. Otherwise, Lordship, what is my fault, Lordship? I have filed evolution in the appropriate format and appropriate time, Lordship, by submitting the requisite fees before the authority, Lordship, despite of the same Lordship. Even also, I was also depriving from getting the rank, Lordship, in the said examination. And because Lordship, political science, I was awarded 93 marks. It ought to have been 95. Whatever maybe Lordship, at least direction may be given. That is my humble prayer, Lordship.
Yes, my lord, these are the expectation of the petitioner, my lord. And mere expectation cannot be a ground to file writ petition. My lord, there is no provision for re-evaluation, my lord. Only rechecking is done, my lord. And kindly see our affidavit, my lord, at para 6, my lord. My lord, rechecking of answer scripts consists of A, retotaling of marks awarded by the examiner, and B, assessment of the answers left out unevaluated by the examiner. But my lord, in the rechecking of the subject, alternative English education, political science, did not reveal any discrepancy, my lord. Then at paragraph 7, my lord, for the subject political science, my lord, against question number 13 and 14, my lord, that was awarded as per the judgment and satisfaction of the examiner, my lord. Similarly, my lord, as question number 16, it was found to be justified by examiner concerned. And question number 27 also up to the satisfaction of the examiner, my lord. And regarding question number 1 of the sociology mark, my lord, the 1 mark should have awarded in question number 1 in the subject sociology, but in question number 24, my lord, 6 marks were awarded in the overleaf of the answer script, which actually should have been 5 marks, my lord, as it was a question of 5 marks, my lord. As such, grand total of marks awarded against question number 1 and question number 24 remains same, my lord. There is no any discrepancy, my lord. Yeah.
It's Lordship, truth is always truth, Lordship, but I have correctly answered, Lordship. That is my belief and knowledge, Lord. So direction may be given to properly re-scrutinize of my answer script, Lordship. As because, Lordship, the event of death.
They filed the affidavit stating everything. You have not filed your reply to this.
No, that is filed, but not on evidence, Lordship. I am on evidence before your Lordship. As because, Lordship, another Lordship in annexer there, page number 137, that is also number of the 12 question, Lordship. Each of the question awarded 1 mark, Lordship, but I was given only 10 marks, Lordship. I have correctly answered 11 question of answer, Lordship. That is affidavit filed by the authority, Lordship, without based on it. Now I am on record.
What record?
So I am.
Examination is of was of my lord 2020, my lord. Now my lord 2023, my lord. The original answer script also already disposed of, my lord, as per the norms of the Higher Secondary Education Council. My lord, I like to submit one statement, my lord. My lord, at paragraph 11, my lord, at page 4. The court does not have expertise to express any opinion regarding assessment made by the examiners who are the experts in their respective subjects. There may be variation in awarding marks from examiner to examiner. No foolproof methodology can be applied in the matter of examination of papers. Then, my lord, paragraph 17, my lord, at page 6. There, the decision of my lord is below, my lord. There was error in the mark sheet due to wrong entry made in the computer. Same is not the case in hand. Even in the said case, the apex court reiterated that the court's interference with the decisions of the expert is very limited. As observed by the apex court, evaluation of two persons cannot be equal. And these are the up to the satisfaction of the examiner, my lord.
Yes.
Lordship will pass the appropriate order on this merit.
And my lord, the petitioner obtained 464 out of 500 marks in the HS examination of 2020.
In how many subjects? Education?
Lordship, education, political science, and sociology. There are 3 number subject. Lord.
Heard Mr.
M. Swayam.
M. Cycle and a council for petitioner. Also heard Mr.
DK Roy.
DK Royal and it's, no, secondary. Who appears?
Assam.
Secondary education,
Element.
secondary.
Secondary revision. Apun
Mr. Assembly Justice and Standing Council Secondary Education Correspondence 1, 2.
1, 2.
And Mr. DK Royal and it's Standing Council.
Assam Higher Secondary Education Council.
Party one, I think.
Respondent 4.
Standing Council, Assam Higher Secondary Education Council for 4. Stop.
Don't check it. Man party.
The
I mean,
petitioner
department.
appeared in the high school.
No, my lord, the higher secondary.
In the higher secondary examination. In the year 2020. Stop. The results were declared on 25th of June 2020. And he obtained 464 marks out of 500 marks. Stop. The petitioner was not satisfied with the marks he obtained in education, sociology, and political science. And accordingly, he approached the Assam Higher Secondary Education Council within oblique response number 4 for re-evaluation of the answer scripts of the concerned subjects. Stop. The petitioner also submitted an RTO application to obtain the necessary the answer script bearing registration number 157774, roll number 738 No, cancel it. To obtain the necessary answer scripts. Stop. Accordingly, comma. The answer script was given to you, correct?
Yes, Lordship, I have reached.
We received the answer scripts with regard to political science. Wherein? With regard to the subjects, he requested for. Stop. It is the case of the petitioner. That in the political science paper. With regard to question number.
Question number 1, Lordship.
Page.
Page number, Annex IF, Lordship, page number 85.
So where's that question paper?
Answer script 85.
No, no.
Question
Question paper.
paper 76, Lordship, page number.
That with regard to this is sociology, not political science.
Political.
Okay,
Science,
then
Lordship, page number
that with
24,
regard to-
27, Lordship.
That with regard to
Annex IE.
subject to this sociology paper. There were that in question number 1. There were 12 questions carrying 1 mark each. And he correctly answered
11 number.
11 numbers, except with regard to question number 1 within bracket C. Stop. However, he has been awarded only
10 marks, Lord.
10 marks. You've been awarded 11 marks.
Lord, political science 11 marks, Lordship, but sociology, Lordship, only 10
Further,
marks.
comma. In the political science paper, where's that? Where's political science?
Question number 13 and 14, Lordship, question paper.
With regard to in the political, with regard to question number 13 and 14. He had answered the questions correctly. But he has not been given the appropriate mark. Stop. It is also the case of the petitioner. That in the education paper. With regard to question number
Question number 1, Lordship.
1.
Yes, Lordship. Annex the I, Lordship.
He has answered
11 number of question
11
correctly answered.
he had, which having 12 questions. He answered 11 questions correctly. However, he has been awarded only
10 marks.
only 10 marks. Stop. Being aggrieved, comma. Petitioners before this court. Praying for direction to the respondents to reevaluate the marks given to the petitioner in sociology, political science, and
Alternative English.
not alternative English, and political science and education.
Education.
Correct. Stop. Para. The respondents have filed counter affidavits. And in their counter affidavits, it is stated that the respondents does not re-evaluate the answers given. However, rechecking of the answer script is done. Stop. While doing the rechecking, comma, the retotaling of marks awarded by the examiner and assessment of answers left out unevaluated by the examiner is being done. Stop. However, comma, in the instant case, while doing the rechecking, it was found that the petitioner had been awarded the correct number of marks and correct number of marks. Stop. Whereas the statement that they've done it further with regard to the political science paper, with regard to question number 13 and 14 of political science, comma, the examiner had awarded marks as per his judgment and satisfaction. And the marks awarded by the examiner are considered to be genuine and proper. It is therefore submitted that as the respondents, particularly respondent number 4, cannot re-evaluate the answer scripts except rechecking the answers. Comma, the writ petition may be dismissed. Comma, stop. I have considered the answer scripts which are annexed to the writ petition. Stop. With regard to the education and political science, this court finds that the petitioner has been awarded marks in terms of the prescription in the question paper. Stop. With regard to the two questions, namely question number 13 and 14 in political science, it is this court is not in a position to assess as to whether the examiner had given the appropriate marks or not, in as much as this court does not have the expertise does not have the expertise in that matter, does not have the expertise to express any opinion regarding assessments given by the examiners who are the experts in their respective subjects. Stop. It is right that court's interference with the decision of the experts is very limited, in as much as evaluation of two persons cannot be equal. Stop. In that view of the matter, comma, I find no merit in the present writ petition, and the same is accordingly dismissed.
Thank you. If some time may be granted to file liability, this has come for the constant after extension note.
Yes, protocol and the counsel for the petitioner on request made by Mr. Aaron Abelda, the presiding counsel. Higher education, not 3 weeks time is allowed to file contract.
Lordship,
I'm appearing for 3 and
This
4, Your
matter
private
after
testimony.
3 weeks. Mr.
V. Rajkumar, Your Lordship.
V.
Rajkhoa,
Rajkumar, Learned Counsel, appeals for respondents, 3 and 4.
3 and 4.
Lordship, may kindly fix a date, your lordship.
Whatever is difficult to fix. a date
Lordship,
at
this man,
stage
your lordship, in fact, your lordship, without any salary, anything, your lordship, that's why, your lordship.
Is the matter again
Is-
on. But it's going to create a chaos after the
After 25th, your lordship, last week of July,
3rd August.
lordship,
Oblige that.
36. Obliged.
Lordship, petitioner here is appointed as a president of the school management committee by an order dated 19/4/2022. My lord, while he was serving as a president, yes, certain anomalies were found, and my lord, he informed to the concerned authorities. While he was waiting for the response of the concerned authorities, my lord, he was served a notice, Annexure 11, page 47, that he was certain complaints were received from the local people. My lord, without serving any notice, without being heard to the petitioner, my lord, he was removed from the president post, my lord. My lord, that is the case of the petitioner. My lord.
May I please, your lordship? My lord, I am appearing for the private respondent, my lord, that is respondent number 7, my lord, who is now at present holding the post of the president. If my lord may be pleased to peruse the impugn order, my lord, which is available at page 47. My lord. Lord, this is an order. This is in fact a communication, my lord, made by the inspector of schools, my lord, regarding cancellation of nomination. My lord, may kindly note the word nomination has been made, my lord, of SMDC president. With reference,
Where is that?
my lord, I am relying on page 47, my lord, annexure 11, last page of the writ petition.
Yes.
Yes, my lord. This is the subject regarding cancellation of nomination of SMDC president. And this is a letter, my lord, issued by the additional deputy commissioner cum inspector of school, who is in charge at this moment, my lord, addressed to the present writ petitioner. And subject is regarding cancellation of nomination of SMDC president. With reference to the subject cited above, I have the honor to state that complaint has been received against you from the local people, and so your name was cancelled by the authority and the new president has been approved by the Honorable Guardian Minister Lakhimpur. Therefore, you are hereby requested to hand over the charges to the new president. This is for your information and necessary action. Accordingly, my lord, I have been already, my lord, taken over the charge, this private respondent number 7. And my lordship has note here that my lord, what the state of Assam has made, my lord, the state of Assam has appointed in each district a guardian minister, my lord, for the purpose of constitution of the school management and development committees, and other issues are also entrusted with that particular guardian minister, my lord. Now here from this letter, my lord, it appears that the authority and the new president has been approved by the Honorable Guardian Minister Lakhimpur. Now this decision of the guardian minister is not under challenge, my lord, in this writ petition, my lord. As I have gone for the prayer part, my lord, it has not been challenged. So, my lord, by relying everything, my lord, if my lordship, my lord, allows us, my lord, after the vacation, this matter can be taken up and we'll bring all this thing on record by an affidavit, my lord.
But Mr.
B. Saikya.
B. Cycle and counsel for the petitioner. Mr. A. Boyan and counsel appearing for respondent number 7 is allowed. How much time?
My lord, immediately after the vacation, as they have some urgency, my lord. My lord.
My lord, kindly fix a day point.
After 3 weeks.
My lord. Oblige.
37.
Mathuni.
May I please, your lordship? Lordship, this is compassionate appointment, my lord. DLC rejected my case, my lord, on 5/10/2021, my lord. With an
Yes,
observation, my lord.
who appears state?
This particular clause is already struck down by this honorable court, my lord.
My lord, in this matter, we are required to obtain instruction, madam. May be taken up after 2 weeks, madam.
Heard, Mr.
HL Ashko, my Lordship, this particular clause is already struck down, my lord. My similar order, my lord.
Against that, my lord, one appeal has been filed, my lord. In delay condemnation, my lord, notice has issued, my lord.
So till now, there's no stay on the.
Similar,
My lord.
similar order I want, my lord. Already struck down by this particular office memorandum, this clause of the particular office memorandum, my lord.
State has filed appeal, my lord, against this order.
We can dispose it of.
Yes, my lord. Similar order, my lord.
So I can.
My lord. My lord,
Already struck down,
this
my
time
lord.
it is
Already
that, my lord,
just
because, my lord,
struck down.
this
So
kind of matter,
yes,
my
ma'am.
lord, most of the matter, my lord, honorable court has issued notice, my lord.
that's why we have issued notice. Till now, you have done nothing.
Yes, my lord.
When was the notice issued? This was issued in 2022.
Yes, my lord.
Till now, you've done nothing. In fact, you don't have instructions also.
Already covered judgment also, my lord.
Thereafter, my lord, this, after issuing notice, my lord, the honorable court, my lord, has struck down the clause 1, my lord.
Yes,
Against that, my lord, we have filed an appeal, my lord.
that appeal is not yet admitted, isn't it?
And no, my lord, delay condemnation is there, my lord, notice
Yeah.
is issued, my lord, in condemnation, my lord.
Then
It is
what
likely
more is
come
left?
to, this to probably, my lord.
What more is left?
Condemnation petition, my lord, notice issued, my lord.
We will dispose it. Just no point in
Yes,
keeping it.
Covered judgment, my lord.
Where's the DLC recommendation?
My lord.
Where's the DLC minutes?
Lordship, page 21, my lord. Annexure 5, my lord. Last portion, my lord. Whereas after thorough scrutiny of the application submitted, it was observed that
Heard,
the
Mr.
HL Ashko, my lord.
HL Askal and the council for petitioner also heard. Elementary, who is appearing? MS Fukan. Then is standing council elementary education for respondent 1 and 2. 1, 2 and 3. And Mr. P Cycle and the government advocate for respondent number 3. Stop. Bharat. The father of the petitioner late Syed Modir Rahman, while serving as a Hindi teacher at Bolipa MB School under Hailakandi Education Block, died in harness on 10/6/2007. Stop. Thereafter, petitioner made an application for appointment on compassionate grounds on 2/1/2008. Stop. The district level committee of the concerned district considered the case of the petitioner in its meeting held on,
5/10/2021, my lord.
where do you find it? In its meeting held on,
Yeah, synopsis.
no, here, where's the page 21?
This is second paragraph, my lord. Whereas after scrutiny of the document, district law has been
In its meeting held on 5/10/2021 and rejected the case of the petitioner on the ground that the remaining balance period of service of the deceased employee was 2 years, 7 months, and 21 days. And in accordance with the OM dated 1st June 2015, the no, 21 days, stop. Erase, you can see it, stop. Clause, which clause is it?
clause 1, my lord.
Ye para.
I have given, my lord, judgment similar. Clause 1 of the office memorandum, my lord.
Where that?
Office memorandum is not annexed, my lord.
No.
Just now, let's say,
Where's the judgment?
Judgment I have given, my lord.
Where's that particular paragraph?
Yes, my lord.
Clause 1 of the office memorandum.
Paragraph 1, my lord.
Dated 1/6/2005. Has been struck down by this court by judgment order dated 31/2023. Passed in WBC 1646 of 2021 as being unconstitutional and being violative of Article 14 of the Constitution of India. Stop. Accordingly, new para. The matter is remanded back to the concerned district level committee, district scrutiny committee or district level committee,
District level.
district level committee to reconsider the case of the petitioner, particularly taking into consideration that clause 1 of the office memorandum dated 1/6/2015 has been struck down by this court. Stop. Let the consideration of the case of the petitioner be done in the next immediate sitting of the district level committee. Stop. With the above observations and directions, this petition is disposed.
Most obliged.
38.
This matter pertains to cancellation of admission of an IIT student. The respondent number 629 has filed one affidavit. I have received the copy today itself. Let the matter be in the next week, and in the meantime, if necessary, we will file a review back.
I am appearing on behalf of defendant number 629. I had already filed the affidavit today, sir.
Mr.
I am Udatta.
Mr.
Udatta.
Dr. Learned Counsel for Petitioner submits that he has received the counter affidavit filed by the respondent number
629.
629 this morning and request for some time to file affidavit in reply. If so advised.
If so.
Stop. Mr.
Vipin Kumar Sharma. Vipin Kumar Sharma.
Learned Counsel appears for respondent 629 and Mr.
AB Day, my lord.
AB
I am appearing for the IIT. Respondent number
Learned
225.
Counsel appears for the respondents 225.
Release
the matter after
Vacation, my
in the
lord.
next week, because he is a student of IIT.
after 1 week.
My lord, it can be after vacation because this case is ultimately very clear in this case, my lord. The
That will decide later.
my lord,
After 1 week.
after a week.
Lordship, after vacation, may kindly fix it for, because I am not in Delhi. I am not in. Yeah. Actually, I am going to Amarnath Yatra. That's why I am requesting.
Yeah, station council.
You are not a station council.
I am out of the station.
Okay, release the matter after
I said,
the.
can it be in the next week? Lord? If
He's saying he's out of
Not-
station law council.
He's
You
not.
are- you-
I am in Amarnath
Release the
Yatra.
matter after the summer vacation.
So that done, Lordship.
Oblige, my lord.
Lordship has fixed it.
No, not it.
Lordship, can you fix it? Otherwise, it will not come, difficult to come in the list. Let it be.
No, when are you coming? When are you coming back?
I will come back 6th of July.
Immediately after reopening, Lordship.
1st August.
First of all,
My lord.
Yes.
I'll
40 order.
So initially, this court has passed an judgment and order dated 16/12/2016. Lordship may come to page 24 of the writ petition.
Yes, then
Page 24. Consequently, both the paragraph 8. Consequently, both the question framed by this court in the order dated 22/9/2016 are answered in favor of the petitioners. Therefore, respondents are now directed to release the regular pay scale of the petitioner as graduate teachers of high school with effect from the date of their joining. The same shall be done within a period of 4 months from the date of receipt of a certified copy of this order. If there is failure to pay the pay scale of the petitioner as directed above within the aforesaid period, the arrear amount would carry interest at the rate of 6% per annum, which may be recovered from the erring officials. Writ petition accordingly allowed with cost of rupees 10,000 to be paid by the Director of Secondary Education, Assam. Thereafter, this judgment was challenged by way of review as well as by 2 numbers of writ appeals, but all were dismissed. And we have preferred this contempt petition. During the contempt petition, they have passed an order which you will find that in the IA 1726.
Yes.
Page 20.
20.
20 of the IA 1726.
Yeah.
In pursuance of the cabinet decision in the meeting held on 22/2021, the government of Assam is pleased to notify and allow the benefit of regular time scale of pay as per ROP rules to following 189 graduate teachers who were appointed in fixed pay during 2001 and now working in different provincialized high school, higher secondary schools of Sibsagar district by arriving their pay notionally with effect from the date of their joining as shown against their names or from any other subsequent date, whichever is later. The payment of enhanced pay shall be made from the date of issue of the notification, and no arrear salary shall be admissible for the past services prior to issue of this notification. This is a clear in violation of the order that has been passed by this honorable court. They have not deposited the cost. They have not released the arrear the salary with effect from the date of joining. Rather, cabinet decision has been taken to give a national to arrive at the pay on a nationally and the area have been curtailed. So this IA has been filed for a direction to comply with the order and also initiate contempt proceeding for repeated violation of the order. And this court by order dated 25/2022 in the IA, the respondents were directed to obtain instruction whether the order has been complied with. 25/2022
In the IA,
Lordship.
there's no order.
25/2021. Or maybe in the main petition also contempt petition
25/2.
2022.
Yes.
Though an order dated 26/2021 has been passed in purported compliance of the direction of this court, so counsel for the petitioner submits that the said notification is not a full compliance as direction given regarding given benefit from the date of joining has not been given, and the order in specific term stated no arrear salary will be paid to the petitioner. Mr. So-and-so counsel for the respondent prays for and is granted 2 weeks time to obtain instruction in this regard. Upon receipt of the instruction, this court may pass appropriate order in the connected IA. Now, nothing has been done. Lordship has seen clear terms. This court has directed to give the regular salary from the date of joining, and if failing with interest at the rate of 6%, the cost of rupees 10,000. Nothing has been done. Rather, this cabinet decision has been taken, ignoring the direction of this court, and they have specifically said the arrear salary will not be paid.
Yes,
I was not here for some time, therefore I could not get the written instruction sometime. I had a discussion yesterday. What the stand of the department is on verbal instruction is that the order of this honorable court on the earlier occasion, the first occasion, it directed that the regular pay scale has to be fixed from the date of appointment. That has been done. The pay scale has been fixed as on the date of appointment. Notionally, taking all that issue, since there was no direct order for payment of arrears as such, or to pay the pay at the pay scale. Lordship will see are now directed. If I may just read that order.
It says to release the regular pay scale.
Yes, madam. I'll just say.
I'll just show my look.
For
Page
release
24,
of
my lord.
regular pay scale from the date of.
Therefore, respondents are now directed to release the regular pay scale of the petitioner as graduate teacher of high school. Release.
With effect
With
from,
effect from their date of joining. So the regular pay scale has been released. My lord. The actual arrear of pay, even my lord, by the orders of the Honorable Supreme Court, my lord, arrears of pay, even on correct fixation of pay, cannot be claimed for a period prior to 3 years of filing of the writ petition. Here, my lord, we have fixed the regular pay scale from the date on which they had been appointed.
you have fixed, but
only-
you have not released.
No, the release has come from they are being released the pay on the regular pay scale, my lord. That is what I'm told. Regular pay scale, whatever pay they are supposed to get on a pay scale, is what they're being given, my lord. It is being released.
The current salary has been given, nothing from the date of joining.
Now,
has
like,
been paid.
only there has been a misunderstanding with the department, my lord. This order came in 2016. The pay scale has been the regular pay in the pay scale has been released from 2021. These 5 years, my lord, I have pointed out to them for that it has from the at least from the date of the order that has to be released in any case. Now, my lord, regarding whether the arrear pay has to come till the date of the order, my lord. That is under discussion. If lawsuit means 2 weeks time, my lord, I will say them what this order actually means, and they will have to have their discussions because, my lord, the persons who are alleged to have committed contempt, my lord, they are between, my lord, between two things, my lord. One, the order of this honorable court, and secondly, a cabinet memorandum. They could have followed one. They should have followed the High Court order, is what I have advised them. But with the cabinet memorandum in the way, not being challenged, is being one of the hurdles. We are trying to sort it out. If lawsuit gives me time till maybe after the vacations, but I'll have some consensus brought into it, my lord.
Clear terms said to release the.
Give him some time. Let's see.
But to comply with the order, what he is submitting, my lord, itself is in contempt. What I am submitting, my lord, they are still thinking whether to release the area.
No, we are not thinking
whether
whether to release the area or not. Whether this particular order requires us to release areas or not.
Whether cabinet decision will prevail or the High Court judgment
It will not.
prevail, my lord, that's what they are trying to questioning.
It will not. That is what I'm submitting. It will not.
What he's saying, they are having a discussion.
We have to bring out a way.
Has seen, my lord, 2016, my lord, the judgment they have, my lord, twice they have gone to writ appeal. They have gone once, my lord, for a review.
Meaning we are not in contempt. We are trying to find out our ways and means of finding out the correctness of the orders passed by this honorable court, my lord. We are not sitting idle. We are going for appeals. We are going for review.
The last judgment, my lord, that was writ appeal was dismissed on 14/6/2019.
My lord.
Thereafter the contempt, my lord, I have submitted representation. Then, my lord, this contempt petition has been filed. Thereafter, my lord, after the writ appeal, they have not gone to, my lord, Supreme Court, my lord. But they cannot say, my lord, the cabinet decision will, my lord, prevail over the, my lord, High Court judgment. My lord. That's what this submission is, my lord. That cannot be, my lord. And in clear terms.
That cannot be.
It is not a wall.
It's a clear terms. This High Court has said that they release the areas, release the, my lord, regular pay scale from the date of joining. My lord, there's no other if and buts, my lord. For fixing the nationality, etc., whatever may be, my lord. But I should be getting this person should be getting their, my lord, regular salary from the date of joining.
Mr. Majumdar,
This is 2
you
years
can
gone
take
by,
appropriate instructions.
My lord, I'll do that. Lawsuit will have it after the vacations, my lord. I'll get 2-3 weeks time, my lord. Because working weeks I'll get 2, my lord. Otherwise, I'll have it sorted out.
This is a contempt petition. It has been like too long.
I understand. I understand liability.
Well, it will be better if the persons are called from, my lord, the earlier also in
These persons are
2022.
not there in the department.
2022, this court has, my lord, the council has undertaken to obtain the instruction, my lord. 25 to 2022.
If by my lord some stretch of imagination, my lord, it is submitted that
Repeatedly.
preterm sites and who are not in the department can be of any use
Senior counsel.
by their personal appearance.
R.S. Mishra, then the counsel to the petitioners. Mr. R. Majumdar, then the counsel appearing for respondents.
For respondent number 1, my lord.
Respondent number 1 submits place for some time to enable him to receive appropriate instructions to apply to this contract. Prayer is allowed. This is the matter of the summer vacation. If on the returnable date, if no appropriate instructions are received, the personal appearance of the concerned respondents shall be considered.
So we will only consider one thing, respondent number 1 has retired in the year 2021. I'm trying to gather the information that was there during his time. He's not in office now. So therefore, my lord, I'm seeking that time. Even the present.
Any improvement has been
No,
done?
my lord, nothing has been done. They are on the old containers. Respondent number
Okay,
2 has
then,
also left the
Mr.
department.
Leonard, Counsel appearing for respondent number 1 submits that the respondent number 1 has retired in the year
2021, my lord.
2021. And therefore he requires some time to receive appropriate instructions in the matter. Stop. Praise Allah, list the matter after summer vacation. If no instructions are received, personal appearance of the concerned respondents shall be considered.
May I pray for a fixed date, my lord? These persons have been deprived, my lord, since my lord, Lordship has seen, my
The
lord.
difficulty is the summer vacation. After summer being fixed, that will create chaos in the court. Costless. If there's an urgency, you can make your mention.
It will be convenient for them also to obtain the instruction if the date is fixed. Otherwise, my lord, sometimes it doesn't get listed. The council is out.
Obvious.
41. Lordship, I'm sorry, Lordship. Lordship, in item 38, Lordship. Lordship has fixed it on first day of Lordship,
August.
Lordship, can it be little bit earlier? Because this is a case of cancellation of studentship, and he is out of his class at present. Even it is, Lordship, decided in my favor, then he will have to lose 1 year. Lordship, he is saying that he will be available after, Lordship, immediately after reopening.
Reopening, I can't fix. You can have it on 28 then.
28.
July.
My lord, may not be on 28, my lord. Maybe on 27th or 26th, my lord.
26th.
26.
Oblige, my lord.
Oblige, Lord. 41.
41, my lord. So this is a contempt petition for willful and deliberate violation of the order dated 18/9/2019 passed by this honorable court. Page 17, my lord.
Well, sometime maybe allowed, we have not received any instruction.
My lord, there was, my lord, after having received notice, this contempt
Well, my lord,
issued by
similar-
contempt number
my lord,
3,
Again.
issued a
freedom
communication
singer
for contempt
is
number
not-
1, when
and
this
he
clearly
is not
says
holding
that pursuant to the government notification dated 25/5/2011, I am legally entitled to what the grievances I projected in my writ petition. There is a notification. This is the my lord, communication dated 16/3/2021. This is the third para, my lord. The petitioner Muhammad Jalaluddin Sheikh was retired from service on 31/1/2012. Before the petitioner being superannuated from service, he had been discharging his duties as a regular project officer continuously, without any break, without any single promotion and financial upgradation, which is legally entitled after completing more than 24 years continuous service as per
Yes.
government notification.
Fuga?
Let me sometime. I have to take instruction. I don't have.
My lord,
It's a 2020 method.
My lord.
He retired on 31/1/2012.
Yes, my lord, already Pitam Saga is also retired, man. So my lord, kindly sometime as well.
Are all these respondents serving in the post now?
My lord, Pitam
My
Saga
lord.
already retired.
Respondent number 1 has retired.
Yes, my lord.
Retired. Commissioner Secretary Government of Assam.
Yes, my lord.
Retired.
Respondent 1 and respondent 3, my lord. 3, he is also not holding the post now, my lord, as a director of secondary education. And my lord, Pitam Saga already retired.
And respondent number 2?
2 is serving.
Then maybe you'll have to file
Yes,
an.
I have to file a IA, my lord, for
Yes,
imprisonment.
I'll give you time to file the.
Yes, my lord.
Mr.
FKR Ahmed.
FKR Ahmed, Learned Counsel for petitioner, prays for 3 weeks' time
My lord.
to file an application going for implement of necessary parties, praise a lot. It's the matter up to 3 weeks. In the meantime, MS Fukan and its council would respond number 1, servicing instructions.
42.
My lord, direction was to, my lord, to examine my claim for provincialization.
Yes,
by
ma'am.
the director.
Already they have passed speaking order, madam. Yes. Order has passed in the WPC number 8616/2018, madam. Joanna Labedin and 50 others.
Your claim for provincialization has been rejected.
May I have a copy of the
Maybe you'll have to challenge this order.
in terms of this order, my lord, the content may be closed, my lord. We'll have to challenge this order.
But Mr. Aram Dekar,
Yes, my lord.
Learned Counsel for the petitioner. MS Fuka, S Fuka, N Fuka, Learned Counsel appearing for responder number
Sole respondent.
Full response.
for the sole respondent as produced in order dated 10 June 2022, issued by the Director, Elementary Education, Assam, whereby the case of the petitioners for provincialization has been rejected. Stop. Para, in view of the order dated, after considering the order dated 10 June 2022, this court is of the considered opinion that the respondents have substantially complied with the order passed by this court. Accordingly, contempt petition is closed. Order dated 10 June 2022 is placed on the court.
I oblige.
46.
My lord, may kindly take up 46, 47 and 48 together, my lord. It's out of the same judgment, my lord. Lordship, at this stage, may I issue notice to the contemporary.
Oh, this is a fresh case.
Pardon me,
Coming
fresh case,
up.
fresh case.
Where's the order?
Order, my lord, the relevant portion starts at 26, my lord. So that we are given permission to participate in the TET examinations. And we are within the qualified range. And this honorable court by this judgment directed to appoint us if within the zone of consideration, within the cutoff marks.
When was the order passed?
This order was passed, my lord. It was passed on 12/21, my lord. And we have initially one contempt petition we filed, which we had to withdraw because of some defect, with the liberty to file a phrase that is at page 37. My lord. We filed it earlier, but we had to withdraw it because of some technical reasons. That order is at page 37.
Even this order, even this contempt which was withdrawn is barred by limitation, isn't it?
No, my lord, we are in continuous, lordship may say it is communication with the department. And department has saying us that they will issue the order.
Whatever it is, what is the period?
My lord, in similar matters, this honorable coordinate bench of this court has already issued notice. My lord, in my respectful submission, if lordship issues notice, at least they will comply. Otherwise,
What is
they
the
have
limitation period?
1 year.
Then?
But lordship may in contempt, my lord, it's not that hard and fast, my lord. Since lordship is in rich jurisdiction, my lord. But is substantial compliance of this and for the ends of justice, my lord. This since your lordship is under Article 226, my lord.
This is not under Article 226.
So that's I understand. It's under the High Court rules, my lord. But the judgment was under Article 226, my lord. These poor people, these people are struggling for years together to get a legitimate expectation.
Mr. H. Amar, concept of issue notice. Petitioner takes steps for service of notice on the respondents by registered post within 1 day.
46, 47, 48.
After 6 days. Same order.
May pleases your lordship. Petitioner is an ITI student, your lordship, who has applied for the post, your lordship, lateral entry, your lordship, that has been annexed in annexure 3, your lordship. That advertisement has been published in Assam Tribune, your lordship. And then, your lordship, I would like to draw your attention to page 21, your lordship. Age.
Yes.
The age limit of ITI pass student is minimum 17 years and maximum 25 years as on 1st January 2023, or SC/ST additional 3 years as per existing norms of polytechnic. And here, your lordship, petitioner is a SC belonging category, your lordship. Your lordship, I have annexed it, your lordship, her certificate, caste certificate in annexure 2, page 19. So, your lordship, age calculation as per notification, your lordship, 1/1/2023, and date of birth of candidate, your lordship, 1/1/1995, and age and calculation of age, your lordship, of the candidate is 28 years 00 months 00 date, and 3 years relaxation is there, your lordship, because she is a scheduled caste belonging category, your lordship. So here, your lordship, after publishing of a merit list, your lordship, I have annexed it as annexure 4, page 23. Serial number 6, Gitika Banik. And her average is 60.16 aggregate, your lordship.
But why is it coming forward?
Yes, your lordship, I am not aware, your lordship. Last time instruction.
Any private respondents are there?
Yes, your lordship. Dipankar
Maybe the.
Malakar, your lordship. Already steps has been taken, your lordship. Page 28. By showing her overage, your lordship, her prayer has been rejected, your lordship. She was not given her seat, and in spite of that, your lordship, Dipankar Malakar, who is average aggregate is 56.43, which is less than the present petitioner, your lordship, he was allotted the seat, your lordship. And right now, your lordship, it was at such a stage, your lordship, already.
You've got an interim order?
Yes, your lordship. Gwalpara, one post has been vacated. And your lordship, the only arising issue is 23rd June 2023, your lordship, online form fill-up date has been commenced, your lordship. I had already been submitted that, your lordship. So kindly, and already, your lordship, there is a principle laid by, your lordship, principle of changing rules of games won't apply when changes regarding selection process and not basic qualification. And here, and for that, your lordship, I am referring some judgment.
No, 1 minute. Why is it coming forward as respondent? The private respondent has not been served.
Served, your lordship, already.
Served.
Yes, your lordship.
Anybody appearing for private respondent?
Service completed.
Service completed.
As per the instruction, lordship, she is over, is it? But calculation has been made in December.
But as per the notification,
serial number 3, if I have marked it with pencil.
a copy it. Move it.
Total. They have calculated it in terms of the lordship that Flag mark A, that annexure A, I have flag mark yellow flag.
This one.
Yes, A, annexure 1, that one. In terms of that, they have calculated, say that the 31st December should be taken into account while calculating the.
31 December 2023, that the date has not been.
Your date of birth?
Your lordship. He is 28 years, your lordship, but as per the calculation, 3 years relaxation is there since she belongs to SC community.
She's not 28 years. She's 28 years, 11 months.
No, your lordship. As per the notification that has been published on newspaper, your
What is your
lordship,
date of birth?
date of birth is 1/1/1995.
Calculate.
And as per the notification calculated dated 1/1/2023, that is 28 years, 00 months, 00 days. And 3 years relaxation is there as per the existing norms, your lordship. Then there is a relaxation on 25 years.
1/1/1995.
Yes, your lordship. And age calculated as per notification, that is the existing rules, your lordship norms, 1/1/2023. I have annexed it, annexure 3, your lordship, page 21. It was clearly mentioned 1st January 2023, then 1/1/2023.
Have you calculated this properly?
Yes, lordship, but we have the calculation is made on the date of 31st December.
That was not
23.
published. That was not published in the newspaper, your lordship, advertisement. So your lordship, there is a referring judgment is there, your lordship. Several judgment is there, your lordship.
Lordship, the calculation has been made taking into account.
The advertisement says 1/1/2023.
Lordship.
His date of birth is 1/1/1995.
As per
Yes,
that,
sir.
her age should be 28 years.
28
0
years.
months, 0 days.
So she's 28 years.
8
Yes,
years.
lordship, but the notification at annexure 1, it says the calculation should be done on the 31st December.
How?
How?
How? What is this logic?
That's the lordship. I have also sought clarification. They have after clarification.
What
also-
logic is this?
That's lordship. I have
When the advertisement says as on 1/1/2023.
lordship is correct. For that, I have sent my short clarification also from the department. They have again sent me this one.
But then it says 31st December of the year.
Yeah.
That was not mentioned here, your lordship.
Yes.
That's the lordship may first, because as per instruction, I have submitted. I have sought clarification also as the lordship has put the query. I have also put them same. But they have said that last date of 31st December of the year has been calculated, taken into account.
31st December of which year? Of the year? Which year?
They have taken into account of 23.
23 December is not
Yes.
approached also,
They
your
have
lordship.
taken 22 lord.
And here nothing has been mentioned.
How can you do that?
Yeah.
Maybe of the year must be 2022.
Lordship,
Yes,
lordship,
your
lordship.
Cannot be
No.
2023.
Lordship, I'll obtain again clarification.
No, your lordship.
Let him get some instructions.
Your lordship,
You have got an
Already-
interim order in your favor.
but your lordship, online form fill up has been commenced from 24th June, your lordship. And she is not been able to take admission also after showing her name in the merit list, your lordship, showing defaulter, showing that over age, your lordship. She is,
Then what is the meaning of having an interim order?
your lordship. But your lordship,
What is the meaning?
Short date may be given, your lordship, before 24th June, your lordship,
24th of June.
before 24th June.
Okay,
Okay, that may be reflected regarding that instruction. That there is
but then the other respondent will have to be heard also.
private respondent.
Is the problem?
Private respondent also there, my lord.
Then I can't fix it on 24, before 24th.
Your lordship,
Says.
or else
protected
your
by the
lordship,
interim order, my lord.
Where's the interim order?
your lordship, dated your lordship, 12/4/2023.
Read it.
Last page 5, your lordship, until further order of the court, the respondent authorities, more particularly the respondent number 1 and 2, shall not fill up one seat in the electrical engineering branch in the state political of Assam for lateral entry to polytechnics who have passed ITI course in post-matric trades from Industrial Training Institute for the concerned session commencing from 2023, as notified by the Director of Employment and Craftsman Training, Assam, on 15/12/20, if the seats mentioned above is already not filled up.
Yeah.
Your lordship, they are not able to take up any instruction, your lordship.
They have come
Regarding
with
the-
instructions. That's why that the only issue is the private respondent will have to be heard, isn't
Yes,
it?
your lordship.
Then can you pass an order behind her back?
No, your lordship.
This is the issue. Hurt MS.
B does,
B does.
appearing for legal aid counsel.
Legal aid counsel appearing for the petitioner. Peruse the order of the Lavazima court dated 35/24. Stop. Notice on respondent 3 shall be deemed to be complete. List the matter for admission after 2 weeks.
Deeply obliged.
My lord, I beg indulgence again, that I could not be listed today because of some defect. So let this
That
matter
is what-
get, yes, lordship. Lordship may post this matter on Wednesday, lordship.
I can do that. MS T. Somlan, counsel for the petitioner, submits that she has filed an IA this morning. However, the same could not be tagged with this with the present petition in as much as there are some defects
Yes,
in
lordship.
the IA. She therefore prays for deferment of this writ petition. Accordingly, list the matter.
Wednesday, lordship, transfer matter with this Wednesday.
Transfer matter, what is the urgency?
Yes, very urgent, lordship.
22nd.
22nd,
Yes.
obliged, lordship.
Yes, finish the other 203.
50.
Why is
But-
it, why is it coming for orders?
Steps have been taken, my lord. Unfortunately, this is not there in the service report, my lord. I have taken the steps, my lord. Page 3 is the Sheba, my lord, and Board of Secondary Education and Medical Department from
Have
Shillong.
you
my lord.
taken steps?
I have taken steps.
When?
I have taken steps yesterday, my lord.
This is the problem.
Unfortunately, my lord,
Not
Sincere-
unfortunately.
sincere apology for
Yesterday
that.
was a Sunday. Where, how did you take steps?
In this case, I have the records, my lord, with me. This is on 19th, my lord, today itself. Today
Today you
morning,
took steps.
today, my lord, 19th, I have received it.
And this order was passed on
This order was passed on 12th, my lord,
16/6/2023,
almost a
before
month.
you took steps. That's why this registry recorded this.
My sincere apology, my lord.
Mr.
A.S. Tapadar, my-
S. Tavatar, learned counsel for petitioner, submits that he has taken steps for service of notice
both
by,
on
by on respondent number
all the respondent, my lord, 1, 2, 3, and 4, my lord, by registered AD and both Dasti, my lord. Dasti was allowed, my lord.
My lord, I am appearing for respondent number 1, 2, and 3, my lord. Board of Secondary Education. Sir.
On respondent number 4. By registered post AD as well as by Dusty Service. Stop. Accordingly, stop. Mr. D.K. Royal, Standing Counsel,
Seba,
Seba, appears for respondents 1, 2, and 3. List the matter after 4 weeks.
Oblige.
Oblige, my lord.
51. In this
Mutha
case, my lord-
Yasta, why is it coming for orders?
my lord, in this case, private respondent,
Lordship,
will appear today.
today, Lordship, for respondent
Okay.
number 4.
Third, AK Putta, then counsel for the petitioner. Mr.
M. Das,
M. Das, then the counsel enters appearance on behalf of
respondent number 4.
respondent number 4. Stop. And Mr. M.S. S. Furkan
And-
N. Furkan, then the standing counsel
Elementary.
appears for the elementary education, appears for respondents 1, 2, and
My lord,
1 and 2.
my lord, in respect of
SCRT,
SCRT, standing counsel is not shown in the cause list, my lord. That may be shown.
okay. Stop. You on time?
Lordship,
Appears for so and prays for how much time?
4 weeks time, Lord.
4 weeks time to file counter. Praise allowed. Use the matter after 4 weeks in the admission column by reflecting the name of the standing counsel as CRT in the cost list.
But
Oblige.
one thing, my lord, but there is an interim order, my lord, 12/5/2023, my lord.
Hmm.
That may continue, my lord, and regarding, my lord, interim order, there is a correction, my lord, may be required. It is
That
a
correction I can't do. You'll have to file it.
correction with regard to this simple correction, my lord. It is written that the post of technician, but it should be a lecturer in education technology.
Interim order passed early to continue to the next. It's up to you.
82.
May I please, your lordship? My lord, in this case, I have taken steps against respondent number 5, my lord, by rest or post,
When?
as well as my Dosti service, my lord. My lord, I may be allowed 2 days time to file affidavit, my lord, regarding Dosti service, my lord.
Mr.
PC Day.
PC Dale and the counsel for the petitioner submits that he has taken steps for service of notice on respondent number 5 by Dusty Service
My-
and prays for 1 week time
My lord.
to file affidavit showing service of notice. Praise
My-
allowed. List
My
the
lord,
matter.
my lord, this matter may be listed along with the writ petition number, WPC number 3298 of
List the
2020.
matter after 2 weeks along with WBC number
3298 of
3298.
2023.
3298 of 2023.
23. Obliged.